disposed of matter in a petition. I filed an application for clarification with regard to the.
When is it disposed?
2 months back, my lord, with advocates matter with regard to the visitation. My lord, in case if he is not able to exercise the visitation rights, the lordship that day told that he can exercise another day, alternate day. There is no specifically that order is not there. Taking advantage of that, she is denying.
What will happen is if you file a Furbing petition after such a long time, first of all, the court will not remember. Even when it is not there, every chance that the other side will also say that there was never the arrangement.
And there is one more clarification, my lord, because on the festivals, my lord, the lordship has directed to give visitation.
Give it, we'll see, list tomorrow.
My lord, CL number 8, I'm filing the memo for withdrawal of the.
We take that. I will take care of that. They're pending the application. Is filed here, is sought for adjustment of the loan advanced by the bank to the petitioner. And so you would contest the pending FDP number 14 of 2019 and sought permission to withdraw the petition accordingly. Memo is taken on record and the petition is dismissed. This is serial number 8.
Then, my lord, I would like to submit a memo for reporting for posting tomorrow. The matter has been settled down outside the court.
No, don't have to mention the memos. Give it to the court officer. All will come tomorrow. It will come tomorrow. Oh, let it come.
Much
Come, doesn't matter. 1 or 2 matters also.
Madam,
Yes.
submission, ma'am. Serial number 4, my lord. And for the respondents, my lord, senior.
Why serial number 4 has to mention it will be reached? And that too, I am not granting any adjournments on at this time. Because everybody is making mention 10 times, if the court is not able to, no, unless and until I see the record, I'll not grant. So please, yes,
Serial number 1 are being spoken to, Sweet Prakash, petitioner, Ravi Elvaidia.
yes. Where is the other matter? Serial number? I'll hear this along with that. He was in the similar matter, he was relying on certain case laws. I think I just want to look at it. Because it is in the same lines, like how you
Well,
stand.
Similar.
37.
That's why after hearing him the same day, I posted it for being spoken to.
It will be taken along with 37.
Yes.
Third
Or
matter,
else it would be easy if it is taken at 2:30 for both of you,
I'll come by 2:30.
2:30,
Please.
along with that 37 or 39. Yes,
for third matter, serial number 2. Santosha Nelputri. Babu J, our respondent.
For the respondent.
yes. Representation on the respondents, the petitioner is present. Yes, what's the matter about?
He was held up in a parted matter.
Sure. Yes,
Petitioner sued, Your Lordship.
Hmm?
Petitioner is the plaintiff before the trial court. Sued for specific performance to execute the sale deed that was done in the favor of the plaintiff. Sale deed dated 25/2/1986, Your Lordship. My ground is that
sale deed date is agreement of sale dated.
25/2/1986.
Hmm.
My ground is that I've acquired the suit schedule property from from the defendant number 1, Your Lordship. And the defendant number 1, not he has suppressed this sale deed and is also he sold this same scheduled property to defendant number 2, and in turn this property has gone to defendant number 3. And in my suit, I filed an IA to stay my suit on the ground that defendant number 3 has filed an earlier suit for declaration and possession, Your Lordship, and that my IA has been dismissed. And challenging the same IA before this court, Your Lordship.
You want your suit to be stayed.
My suit to be said. My suit is a successive suit, Your Lordship. In the earlier suit, I filed an IA. In the suit that was filed by the defendant number 3, I filed an IA for court commissioner to be appointed to examine exhibit D10, Your Lordship, which is the sale deed dated 25 to 1986 that was done in my favor, and also the signature found in the sale deed that was executed by the defendant number 1 in favor of defendant number 2. And court commissioner was appointed, and on this ground, I filed a IA in the successive suit that I filed to stay my suit until the court commissioner report was received in the earlier suit, and that came to be rejected.
Rightly, let's see.
Please, Your Lordship.
Let's see the order.
Please. Annexure G is the order, Your Lordship, 36 to page number 36.
Please read.
It's my IA came to be rejected on the ground that
Let's read the order.
please.
Para number 11.
Para 9, Your Lordship. In the present case, the applicant has filed the present suit for relief of specific performance of contract by virtue of unregistered sale deed dated 25 to 1986 by cancelling the sale deed stood in the name of defendant number 2 and 3 against the defendants. The defendant number 3 also filed another suit against the plaintiff herein for declaration of title, eviction, and damages. And such relief were regarded to the suit shared property on the basis of unregistered sale deed executed by G. Narayan Swamy, son of Gullappa, to his father as Exhibit P9 in the above suit and Exhibit D10 in OS number 93 of 2008. 93 of 2008 for specific performance of the contract. This is my suit, Your Lordship, 93 of 2008. The first defendant also filed a suit in OS 93 of 2008 for recovery of possession, where the suit he's taking the defense of based of unregistered sale deed executed by G. Narayan Swamy, son of Gullappa. He's also disputing the signatures of G. Narayan Swamy, son of Gullappa, found in Exhibit P9 and Exhibit D10 in OS 93 of 2008. They have filed an application for appointment of court commissioner to compare the signature. This court will be pleased to appoint Truth Labs as commissioner. Now the matter set down for awaiting report from court commissioner. They say the applicant is without commissioner report. It is not permissible to convince this court. On the other hand, the defendant argued that this case is 7 years old matter. The nature of the suit in both suits are entirely different, except subject matter and parties. Hence, section 10 is not applicable. Section 10 of the CPC clearly had that the court can stay the subsequent suit, but not previous suit by the parties and not stay the further proceedings. Already both side evidence were closed and plaintiff counsel took 3-4 adjournments to address his arguments on merits. The counsel for third defendant already canvassed arguments on merits of the case. Moreover, the nature of suit in OS 93 of 2008 and the present suit are entirely different. The issues involved in OS 93 of 2008 and as well as this suit are entirely different. The suit OS 93 of 2008 is for relief of declaration of title and delivery of possession, and the present suit is for specific performance of contract. When issues are not identical, the court cannot grant or stay under inherent power of court. The closure of evidence of both parties and at the stage of arguments on main matter, and the matter in issues involved in suit are not directly and substantially an issue in this suit. In the present suit, the plaintiff has to establish his father purchased the suit scheduled property from first defendant on 25 to 1986 under unregistered sale deed, and he is ready and willing to perform his part of contract and subject matter of the suit. In OS number 93 of 2008 is different one, and the relief is declaration of title and possession, hence the issues involved in both suits are different one. On perusal of section 10, it's quite clear that whether the parties of the suit and the relief claim
And
by
there is a stay in this matter.
please allow.
So successfully from 2017 to 2025.
There's a stay.
Your
There's
suit is
stay.
stayed.
My suit is stayed.
It's all the more reason to dismiss it. Yes,
Your Lordship, mine is the successive suit, Your Lordship.
let it go on. Let it go on. Yes.
My respectful submission is, my lord, the reliefs are different, my lord. Therefore, my lord, section 10 is.
Your Lordship, I didn't.
What is 2.1?
My lord, 2.1 is I have filed an application, I have filed the writ petition, my lord, challenging the order of appointing of commissioner, my lord, for comparing the signatures of the disputed signatures and the admitted signatures.
What is that? Page number. Impugned order.
Impugned order page number is 33, my lord. The discussion starts, my lord, at 36.
Please read.
The admittedly, the plaintiff has filed a suit for relief of declaring the rights and the defendant,
Second, first defendant or second, third defendant?
Third
third
defendant.
defendant. My lord, she is claiming, my lord, right under a unregistered sale deed. I am, my lord, claiming under a registered sale deed. First of all, she has to establish.
Please read, then you can make your submission.
Admittedly, the plaintiff has filed a suit for relief of declaration of right and the declaring the right and the defendant to vacate and hand over physical possession and direct to pay arrears of rupees 3,500 by way of damages from the April 2017 till date. Admittedly, the plaintiff has filed a suit for relief of declaration and possession of the suit scheduled property. It is the case of the applicant that his father is in possession of the suit property on the basis of an unregistered sale deed dated 25/2/1986, executed by the plaintiff in favor of the father of the applicant. Both the parties have completed their evidence, but in the written statement and also in the evidence, the defendant has denied the signature found in the unregistered sale deed. It is marked as D10. Hence,
What stage this application is filed?
after the evidences are completed, my lord.
Hmm.
After the evidence is completed, the application is filed for appointment of a commissioner.
When was the evidence completed? You have a date?
No, I don't have it.
Yes.
Immediately when the cases
This is
are
of the year 2008.
2008.
Application is filed when?
Filed by me. I
When?
filed the application.
2017, my lord.
Yes.
2017. Admittedly, my lord, your lordship is very well aware. When the sale deed or a document is registered, my lord, the presumption is, my lord, that the owner has executed the sale deed in favor of the
But she want the registered, the signatures on the sale deed and
unregistered sale deed to be compared. My defense is, my lord, based on the reliance of the Supreme Court judgment and other honorable High Court judgments, my lord, that when it is clearly the trial judge has got the power to identify the signature based on the available document, and therefore these documents need not be referred to the handwriting expert. The second point is, my lord, suppose if two registered documents are there, my lord, and those two documents are referred to the handwriting expert, my lord, then the court, they can get an opinion. Here, my lord, it is one case is a unregistered document, and other case is a registered document.
that there are no admitted.
No other document. The defendant has to prove, my lord, by producing other materials to show
No,
that.
no. I'm saying there are no other admitted signatures on record of the one who has executed the sale deed.
Please.
No, my lord, the evidence, the signatures found at the time of recording evidence, written statement signatures, other signatures are available before this court.
Is arrayed as defendant number? One who has executed the sale deed in your favor.
Unregistered sale deed.
He filed the suit.
You have the registered sale deed in your.
I have not made him a party, my lord.
Hmm.
He's
Hmm.
The person who has executed the Srinivas is, I am the person, my lord, in whose favor the sale deed is executed.
Now let us understand. OS number 93 of 2008 is filed by
defendant number 3, your lordship, who is
By me,
by me.
by you.
Yes, Narayan sir.
Speaking declaration and possession.
position.
According to you, who has executed the sale? That one is not a party.
That one is not important.
Who are the defendants in your suit?
My Srinivas.
I am Srinivas.
So you are seeking recovery of possession from him.
Please.
Hmm. In your suit, who are the parties?
G. Narayan Swamy is the defendant number 1. Defendant number 2 is one Kitama. And
Who has executed the sale deed in your favor?
That Kitama.
no, your lordship, not Kitama. Narayan Swamy has executed the sale deed in
Who is
favor of my plaintiff.
Narayan Swamy is a different.
Please. Defendant number 3, defendant number 1. And defendant number 3 is the one who's filed the suit.
1 and 3 are both Narayan Swamis, my lord. Yes,
But not the same parties.
not the same.
How can he be your, because he has purchased, both of you have a common vendor.
Please, your lordship.
Who is he, D1 or D2?
D1 is G. Narayan Swamy,
From whom you purchased?
who I purchased.
And in your suit, you don't take any of the pleas.
Please, Your Lordship.
In your suit, what is the case of defendant number one?
He has not taken any contention, Your Lordship. Defendant number 3 is also the one Narayan Swamy who's filed the previous suit.
That is he.
That is
The
the-
D3, because he is the
Yes, please.
subsequent purchaser having a sale deed. D2 is whom?
Srimati Kitama, to whom, which register sale deed is also in question. That sale deed, the signature in that sale deed, and also the sale deed that was in my favor, I'm trying to I've asked to,
No. Why did you make Sitama a party?
because she executed a sale deed in favor of defendant number 3, Your Lordship. That is G. Narayan.
Is it your case that D1 executed to D2, D2 executed to
Please,
D3? in turn?
Please.
Uh,
And D3 filed a suit in 2008, Your Lordship.
Seeking declaration and recovery of
Declaration,
possession.
please.
Uh.
In OS 93 of 2008, I filed an,
So, in his suit, you are a party,
yes.
and from 2007 until 2017, you have not realized that certain application to be filed. Now you will file an application, seek an order, then again you will say that my state be sued. Please come.
Your Lordship, it may not be directly related, Your Lordship. It's substantially the
That
same.
I'll answer your argument. Common order, WP 26543 and WP 17565. The WP number 17565 of 2017 is filed by the plaintiff in OS number 93 of 2008.
Your Lordship, may I make one submission? It may be clubbed together and be heard, Your Lordship.
93, that you should have done long back, not now. The 93 of 2008, seeking declaration and injunction, seeking declaration, recovery of possession. In the said suit, the defendant in the said suit, the sole defendant had filed OS number. What is the OS number?
93 of 2008.
Ahura ke 4 of 2000.
4 of 2009.
Nine.
4 of 2009.
Filed OS number 4 of 2009, seeking specific performance of an agreement of sale dated 25/2/1986. In the suit filed by her, the plaintiff in OS number 93 of 2008 is arrayed as defendant number 3, and his vendor is arrayed as defendant number 2, and the defendant number 2's vendor is arrayed as defendant number 1, from who is alleged to have executed an agreement of sale in favor of the plaintiff in OS number 4.
4 of
4 of
2009. In OS number 93 of 2008, defendant number 3, who is the plaintiff in the other suit, had filed an IA number 17 under order 26 rule 10A to appoint the handwriting expert as court commissioner to compare the signature of the signatures found in exhibit D10, that is a registered sale deed in favor of the D10 is a registered sale.
Registered.
I think D10 must be agreement of sale.
Agreement of sale dated
D10
25 to
agreement
19.
of sale with the signature found in the sale deed executed by the vendor of the plaintiff. That came to be allowed by order dated 25th March 2017, whereby the court had allowed the application and observed that observed that it's well settled principles of law that the court can compare the disputed signatures, but as an abundant caution, it has to be referred to the handwriting expert. Further, the applicant is able to establish his case with the assistance of handwriting expert. If the opinion is furnished by the expert, it is only an opinion and not a conclusive proof. the court should take the assistance of the expert to examine the disputed signatures with the other admitted signatures. And it's very much necessary to send the disputed signatures of G. Narayanaswamy found in Exhibit D10 as prayed by the applicant, along with the signature found in the sale deed executed by G. Narayanaswamy in favor of Kittamma. Thereafter, the plaintiff in OS number 4 of 2009 had filed page number, your writ petition.
32, Your Lordship. IA filed by me.
Had filed IA number 11
11.
under section 10 of the CPC to pray the suit filed by her, filed by the filed by her in that is seeking specific performance, that is OS number 4 of 2009, till the receipt of the report from the court commissioner in OS number 93 of 2008, that came to be dismissed by the court by order impugned dated
6.
June 2017 in WP 26543 of 2017. Vidya, in the other matter, that court had allowed that application, aggrieved thereby WP number that is impugned in WP number 17565, earlier one of 2017. That order dated is, what is the order in your case?
23.
25/3/2017, ma'am.
25/3/2017. Both the plaintiff in invoice number 4 of 2009 and the plaintiff invoice number 93 of 2008 are before this court by way of these two writ petitions, as the parties are one and all the parties are served, as the parties are one and the same, and the disputes are interrelated. This court is disposing of these two writ petitions by way of a common order. Next, learned counsel for the plaintiff in the specific performance suit submits that the IA that is allowed by the court invoice 4 of 2009, whereby the court has directed the court commissioner to compare the signatures on the unregistered agreement of sale and agreement of sale or sale deed.
Agreement, sale deed, Your Lordship.
Unregistered sale deed.
Unregistered sale deed.
Unregistered sale deed with that of the registered sale deed in the other suit that by the plaintiff. And as the commissioner's report is awaited, unless and until the proceedings are stayed in her suit, her suit proceedings are stayed, it would cause a lot of prejudice to her. These aspects were not considered by the court. Then counsel submits that the court, the reasoning that is given by the court while dismissing the application filed by her is contrary to the settled law. The learned counsel appearing for the respondent number,
That's 3.
respondent number 3 in WP number 26543 of 2017 submits that the relief that is sought is a specific performance of, what is specific performance?
They should have filed for a declaration, my lord. They have sought for specific performance of an unregistered sale deed.
Of the unregistered sale deed, Your Lordship.
How can there be such a relief? What is specific performance?
Sale deed, I'm there also.
Sale deed is executed,
Please,
it is not registered,
it's not.
then what is specific performance?
Your Lordship, it's fine.
I think it's specific performance of a sale deed. The relief that is sought by the respondent in OS number 93 of 2008 is seeking declaration and recovery of possession basing on a registered sale deed. He submits that both the reliefs that are sought are unconnected. And the court had rightly considered all these aspects and rightly dismissed the IA number 11 that is filed by the plaintiff seeking stay of all further proceeding. He submits that in his suit, allowing an application filed to compare the signatures, appointing the court commissioner to compare the signatures on the unregistered sale deed and the registered sale deed also is not permissible, and the order that is passed by the court is contrary to law. He submits that the court has the power to compare the signatures, and that apart, the application is filed in 2017 in a suit of 2008,
9.
in a suit of 2009. He submits that it is nothing but to protract the proceedings. It is submitted that after the arguments are completed,
3 dates, my lord, they have taken for arguing and thereafter files this application.
after the entire evidence is completed, and after the plaintiff's evidence is completed,
Completed.
at that stage, the present application came to be filed. The manner in which the defendants are pursuing the defendant in OS number 93 of 2008 pursuing the matter shows that only with their intention to drag on the proceedings, as they do not have a case on merits. They're filing these kind of applications, and court ought not to have allowed the same. In response to that, the counsel appearing for the respondents in WP number 17565 of 2017 submits that it is right from the beginning. It is the specific case that the signatures on the sale deed are forged signatures, but do not belong to the vendor's vendor. Vendor's vendor in that case. Though the court has got the power, but the court is not an expert to compare the signatures. As such, the court had rightly referred the matter, had directed the commissioner to place a report. If once the report is placed before the court, it would help the court to decide the issues between the parties in a more, it is submitted that there is no illegality with the order impure. The counsels on either side peruse the material on record. The suit for specific performance, can I see the relief in your suit? Prayer.
Yeah. Page number 12, Your Honor, Annexure A.
Relief is at page number.
Relief is on page number, in page number 15.
How can you call it a specific performance? This court has perused the prayer in respect of OS number 4 of 2009. The prayer says to direct the respondents to execute the registered sale deed in favor of the plaintiff pursuant to the unregistered sale deed dated 25/2/1986 by cancelling the sale deed stood in the name of defendant number 2 and 3. The suit is filed in the year 2009. 2009. The defendant number 3 in this suit had filed another suit, that is OS number 93 of 2008, seeking the declaration that he is absolute owner of the property and also sought for recovery of possession. In both the matters, the evidence is completed, and in OS number 93 of 2008, even after the arguments are entered by the plaintiff, completed by the plaintiff, the defendants comes up with an application to compare the signatures. That too, the signatures on the unregistered document and signatures on a registered document. When that is a specific, that is a specific plea that the signatures are forged, it is for the defendant number one to say whether he has executed the signature or not. When the defendant is a party to the suit, it is not for the defendant number plaintiff to say, it is not for defendant, that application is filed in your suit. That is
Right,
not for defendant number three, you are three there.
I'm three,
Defendant number three. No, you are defendant number one in his suit.
I'm
Ah.
in defendant number one, his suit, and in his suit, I'm defendant number.
Delete that. When now they are seeking, in the suit for declaration, the defendant, the vendor is not a party. And in the other suit, the vendor is a party. And even in that also, when she is seeking cancellation, no such application is filed in the suit that is filed by them. That is OS number 4 of 2009. No, after the arguments are over, they come up with this application in the other suit, both on the basis on the latches, and not filing an application in the other suit, and coming where the defendant number one, who is the vendor, is there as a party, and when already a written statement is filed, when they are contesting in the suit, the outcome of this would not have any bearing on the other suit. And that apart, the parties cannot be permitted to come up with these kind of applications after almost a decade. And on the face of it, it appears that only for the purpose of protracting the proceedings, these kind of applications are filed. The court ought not to have entertained such an application. And even in the entire order, there is no whisper why they have not come up with such an application at an earliest point of time, and why the court has entertained the application. In that view of the matter, the order passed in IA number so-and-so, invoice number 93 of 2008. IA number 11, or what is your IA?
IA number 17, ma'am.
IA number 17, invoice number 93 of 2008, dated
25/3/2017.
25/3/2017 is set aside, and the writ petition is allowed. WP number 26543 of 2017, as there are no merits, the writ petition is dismissed, performing the order of the trial court. Any of the expression, any of the observations made by this court while deciding this application shall not be construed as an expression of this court. And the court shall dispose of the suit within 6 months. Court shall dispose of both the suits within 6 months from the date of receipt of the copy of the order. Both the parties shall not seek any unnecessary adjournments. In WP number 26543 of 2017, Mr. Aravind Babu undertakes to file of the wakalat within 1 week from today.
K. Shivshankar, for petitioner.
For the petition.
A. Ramakrishna.
Where is the respondent?
Respondent is not appearing. That's
Do that.
the petitioner.
Heard the learned counsel, no representation. Do the file. Some advocate is appearing. R1 to R4.
It's wakalat they filed, but they're
He is
continuous.
the one who is not present last.
Yes, it's in all the
Yes.
dates.
Yes. What is the
That's-
suit for?
That's the petitioner is has filed the suit for the relief of permanent injunction. That suit came to be decreed. Subsequently, minutes after the decree, they violated the order of injunction, they started interfering with the possession of the petitioner. It's the violating the judgment and decree.
You are the plaintiff.
Yes, minutes, plaintiff.
Suit for?
After suit for permanent injunction.
Hmm.
That suit came to be decree. It's immediately after the decree, the defendants, that is the respondents here, they started interfering with the possession. Immediately, the execution petition came to be filed. In the execution petition, my lords, the application has been filed under section 151 of CPC seeking police protection. Because there is a judgment and decree, they're violating the judgment, give police protection, my lords, that application. The trial court, without considering the case of the petitioner, it's a dismiss the application. That means the civil court has no jurisdiction. Court cannot grant the police protection, and that
my lord, may I submit, my lord? Court audio is muted, my lord.
Dated 15th December 2017. The defendant number. Your defendant number?
Number. Two, my lord, two.
Defendant number 2 is before this court. The respondent herein has filed the suit seeking injunction and also seeking partition and separate possession of her
1/8 share.
1/8 share.
Mm.
In that, she has come up with this application, praying to sell the usufruct of the areca nut trees and coconut trees, which are situated in the suit item number 1 through auction, and direct the defendants to deposit the sale proceeds of the sale proceeds. The defendants have come up with objections stating that there was a oral partition earlier, and as per the partition, they have been enjoying the property. Now, if such an order is passed, it would cause a lot of hardship to the defendants. They would be left with no income. The court, by order impugned, has observed that when the relationship is not in dispute, and when the plaintiff is a member of the joint family, a member of the family, whether there is a oral partition or not, all these things will be decided in the merits of the matter. Unless and unless and until the interim order is granted, whereby the sale proceeds are deposited in the court, it would cause a lot of prejudice to the plaintiff. Considering all this, the court has held that the defendants number 1 to 7 are directed to sell the usufruct of suit item number 1 through auction and to deposit the share of the plaintiff which derives from the auction after deducting the expenditures in the court. The defendants 1 to 7 are not directed to deposit the entire sale proceeds in the court, but they have to submit the proper accounts before the court. The auction has to take place in the presence of the court commissioner, and the court commissioner has to submit the report in respect of the auction to the court. The plaintiff is at liberty to choose her choice of advocate as court commissioner, and accordingly allowed the petition. Agreed thereby, the defendant number 2 is before this court. Then counsel appearing for the defendant submits that the court, there is a oral partition. The share of the parties is not determined. At this juncture, if such an order is passed, it is not in the interest of the defendants, and the case of the defendants is not properly considered by the court. Next part, learned counsel appearing for the respondent, respondent number 1, she is appearing. Respondent number 1 submits that the court, is it? Respondent number? Who is respondent number 6?
I appear for respondent number 6, my lord. I'm only a formal party, my lord. I do not have anything to do with the.
Counsel for the respondent number 6, who is a formal party, submits that the court has passed a reasoned order. How many respondents are there?
But, sir, 8 of them.
Then my cause list is reflecting about only R1 and R2 and R3. What about notice to all of them?
Only 6 are there,
You
different.
represent whom?
Petitioner,
Only one.
one.
Then where are the other parties?
Oh, no. Our Puttama, Timmaya and Chappa, their brothers are there.
No, in the suit, there are how many defendants?
There are 8 defendants, my lord.
There are 8 defendants.
8 defendants.
Petition is filed by how many defendants?
Only one, Narasamma.
Then what about notice to the other defendants?
Oh, yes, my lord.
Why the cause list is silent on that? Is it item number 4?
One item number 1.
5. Shubha is for R6.
Yes, my lord.
R2, R3, R4.
Before the trial court, I am defendant number 8, my lord, executive
This court
engineer.
had, for Shubha, for R6, advocate appears. R2, R3, R4 is, those served, no Kalat is filed. What is this wide order? R1? The notice to this court by order dated 9/1/2025. 29/7/2021 held notice to R1 sufficient. And the petition as far as R5 is concerned, as they have failed to take steps, notice to R5, as far as R5 is concerned, is dismissed. Next para. Having heard the counsels on counsel for the petitioner and the counsel for respondent number 6, there is a material on record. The plaintiff has filed the suit for partition and she is claiming 1/8 share. The relationship between the parties is not in dispute. According to the defendants, the partition has already taken place, which is on the merits of the matter. And the court will decide eventually during the course of trial. Now, it is a contention of the counsel for the defendant, unless and until the shares are
Determined.
now they cannot deposit the amount, considering the fact that showing the array of the parties, and she has sought for 1/8 share. And at this period, at this point of time, the court has rightly considered this and asked them to deposit only 1/8 share, and the remaining share, the plaintiffs are at liberty to enjoy the same, and they have to place the accounts before the court. In the considered opinion of this court, the order that is passed is an equitable order, and no interference is called for, accordingly dismissed. Next.
Serial number 6,
Much obliged.
the petitioner, K. Venkatesh, for R2.
I apologize, my lords. In the last occasion, I was online. I
Yes.
could not make myself.
Yes,
Lords, this is a suit for possession and mandatory injunction, lords, filed with the petitioner.
where is the counsel for respondent, K. Venkatesh? Delete from the caption dismissal, for the counsel for the petitioner in part, no representation for the respondent. This is marked tomorrow as part heard. Yes, next.
Serial number 7,
Great.
serial number 7, K. Madhusudhan.
Sorry, madam, the other day, by the time I could come, there was. These two writ petitions are filed by plaintiff, petitioner and, plaintiff and respondent defendant number 2, defendant number 1, madam, challenging the order passed by the court.
The first writ petition is filed by you, are the,
I am the plaintiff.
and second writ petition is
Is
by the.
filed by defendant number 1, madam.
Oh. What is the suit
Jagdish
for?
Gowda alva? Erandi defendant.
What is the suit for?
Suit is for declaration that I am the owner of survey number, site number 250, which is a site measuring 40/60, formed in a approved layout. The defendants are the adjacent owners on the either side of the two sites. At the either side of my site. One defendant is the owner of 214, another defendant is the owner of 260. My specific case is because I was not staying in the place where the site is located. Both these defendants have put up construction, encroaching the entire site belonging to me. In that background, I filed a suit for declaration that I am the owner of the site and also for possession of the respective portions of the property which have been, according to us, encroached by the two defendants who are the adjacent site owners. But evidence was completed. Thereafter, my lord, a commissioner was appointed. And a commissioner in the report, my lord, he submits a report stating that there is only
What
an
for the commission is appointed?
for the purpose of measuring and identifying the encroachment.
Hmm.
Because the
At
sites
what
are,
stage?
what he said is,
At what stage is
after
appointed?
the evidence is over, that is the stage when we could have filed the application that has been done. And what happened is the commissioner gives a report saying that both these defendants have only encroached 10 feet by 60 feet. But whereas he also admits in the course of the cross-examination that the entire site is built up.
Hmm.
My entire site is built up is what he says. What, so patently there is an illegality in the very approach of the commissioner, and whether he had measured it as per the layout plan or not, all those things, there was a lot of confusion. In fact, I produced the cross-examination of the commissioner also, who was examined at CW1. Even his evidence also clearly indicates that he has not applied his mind. He himself says the entire site is totally built up. If 10 feet, if they have only increased 10 feet each on the either side of the site, I should be having a vacant site of another remaining at least about how much, 20 feet by 60 feet. According to the commissioner himself, it is completely fully built up. So in that background, I filed objections, I cross-examined. And the defendant number 2 also filed objections, and they also cross-examined. We all of us sought for,
So not happy with the commission
No.
report.
both me
But
and,
to them, they have not encroached.
according to them, the extent of encroachment is something there is different, and whatever it is, minutes. Ultimately, what happened, both of us have challenged the order passed by the court below, accepting the commissioner's view. Our submission is, so far as my submission is concerned, when the commissioner himself says in the cross-examination, the entire site is built up. His sketch that only 10, his report that 10 feet on either side. In fact, the court also says so.
Is it correct that he gives in the cross-examination, he says the entire site is built up?
Please, your lordship, and also there are discrepancies in his own submission in the cross-examination, your lordship. In the report, it states that all the sites are of different measurements, your lordship. But in the cross-examination, he admits that the sites are of the same measurement. But however, in reality, the sites are of
Then we'll do
rectangular.
one thing, we'll set aside this order and fresh commissioner be appointed.
That's what, Miller. Actually, I can even draw your honor's lordship's kind attention to the relevant portion of the cross-examination. I have produced it.
Let's come to the order impugned,
Yes, ma'am. And it go to the
page number.
page number. The order starts from page 41 in my writ petition. The relevant portion, your lordship gets it at page 44, in page 44.
40?
In page 44, Miller.
Yes.
The the relevant portion is this, after referring to the objections filed and all that. Both the parties have filed up. Thereafter, Miller, kindly go to the next page, Miller. The court commissioner has, after referring to the objections filed by both the parties, the court below says, thereafter the commissioner has been summoned and examined as CW1 and got documents marked as exhibit so and so. CW1 is subject to cross-examination by learned counsel for the plaintiff and defendants 1 and 2. I have heard the arguments on both the sides, and they produce the oral evidence of CW1, document evidence at C1 to C7 and materials placed on record. Then kindly go to the reasoning portion. After referring to the nature of the suit and in paragraphs 9 and 10, Miller, the relevant portion would be para 11, Miller. Kindly go to para 11. It is after the close, your lordship gets it, Miller.
Please read.
It is after closure of evidence of both the sides. The court commissioner has been appointed to ascertain the measurement of site properties bearing numbers 214, 215, and 216, and to submit the report along with the sketch, and accordingly has submitted the report along with the sketch. CW1 has stated in his evidence that he has received the commissioner's warrant vide exhibit P1 vide dated 22/7/2017, and accordingly has issued notices to both the plaintiff and defendants, and vide dated 11/9/2017, fixing the date of measurement of property on 27/9/2017. It is further evidence of CW1 that on 27/9/2017, he has visited the plain schedule properties, measured and demarcated the plain schedule property in the presence of the plaintiff and defendants and also witnesses. He has prepared the measure dated wide
At
exhibit.
para number 20, what do you say about this?
Yes, ma'am.
It is also forthcoming in the evidence of CW1
Yes, ma'am.
that the owner of the site number 214 and 216 have encroached on PT in site number 215.
Yes.
No, he has given
What is happening is
are
this,
you disputing, no, it is like this. Are you disputing the commissioner's report itself You're saying that what has been
I am
stated by the-
disputing the very commissioner's report itself because based on the evidence of commissioner in the course of the cross-examination. In the evidence of in the report, what he has said is both the defendants who are the neighbors on the either side of the site, they have encroached 10 feet each into my property. Whereas my specific case is I have not put up any construction. These people have put up the construction entirely in my site. And the fact that the entire site has been built up is admitted.
all the three of you,
Yes,
that is
ma'am.
defendant number 1, 2,
And the plaintiff.
and the plaintiff,
Yes,
are
ma'am.
claiming the property by way of a registered sale deed in a layout.
Yes, madam.
And the whatever is land that is
Yes.
measuring is mentioned that the so and so you hold so and so
Correct.
land. In that case, what is the difficulty?
The difficulty is this. If I have to get a decree for possession against the defendants, the extent of encroachment by either of the two defendants,
No, that I understand. What is the difficulty to measure the land and why should there be a discrepancy of this nature?
that's what, why, that's the,
Court commissioner,
yes, madam.
who is the court commissioner?
A surveyor was appointed. He goes there. He, according to him, has taken the layout plan. In the course of the cross-examination of the DW2, defendant number 2, he says, I have not taken any document to this spot other than the layout plan, other than the commissioner's warrant. In the other side, when I cross-examined, he said, I have taken the layout plan. And apart from that, his own evidence is inconsistent. These were made respectful submission with the report
The simple issue has been complicated and suit of 2014 is pending.
pending. Your lordship may kindly direct the trial court to appoint a commissioner immediately. So once the commissioner is appointed,
Then again, another round of litigation for both of
we
you to
can't
come to
help
the
it.
high.
That what is happening is here in this particular case,
Because nobody wants the litigation to.
no, we want the litigation to be completed. In fact, I have moved this matter on several occasions. Unfortunately, many times the matter did not reach. And that's how it has happened. In fact, from last almost 6 to 7 months, we have been repeatedly trying to move the matter. Only on the last occasion, day for yesterday, when the matter was listed before your lordship, by the time I could come here, the matter was called and your lordship said posted.
Unfortunately, when the court wants to hear, you are not present.
No, not like that. It was, I mean, by the time we could finish other matters in the other court and rush here, it so happened like that. Normally, your lordship takes substantial time for deciding cases. So I thought, this matter would reach little later on the other day.
Please come. Agreed with the orders passed on the commissioner report dated.
Commissioner's report is dated.
No, not the commissioner report stated.
Order.
Dated.
Order is dated
26,
26 to 2019.
26 to 2019 in OS number 17414 of 2014. Both the petitioner, both the defendant, both the plaintiff
And
and the defendant number 2.
2 minutes.
Defendant number 2.
Defendant
or
number
before
1,
this
Jagdish
court.
Gowda.
The plaintiff.
I'm sorry, this. 1 minute, Jagdish Gowda is defendant number 1. That is, her client is defendant number 1, not defendant number 2.
And defendant number 1 or before this court. The plaintiff's writ petition is W2181 of 2019. And the defendant's writ petition is defendant 1's writ petition is
I'm sorry, there is
For 2 years.
2 only. There is-
defendant number 2. It's not 1. Defendant number 2. Defendant number 2's writ petition is WP 52439 of 2019. The plaintiff had filed the suit seeking declaration and
And also possession of the
Recovery of
encroached
possession.
portions of the property from defendant.
possession of the encroached portion by the defendant number 1 and 2. According to the plaintiff, he is the absolute owner of an extent of
A site measuring 40 by 60.
site measuring 40 by 60, and it is his case that both the defendants have encroached the land and made constructions. After the court had appointed the court commissioner and court commissioner has placed his report. As for the court commissioner's report, both defendant number 1 and 2 have encroached
10 feet each.
10 feet each. It is a case of the plaintiff that in the cross-examination, the defendant, the court commissioner has stated that the entire extent of land which the plaintiff possesses, there are constructions, and it is a case of the plaintiff that he has not made any construction. It is a case of the defendant that he has measured the property contrary to the memo of direction issued by the court. And he has not properly mentioned he has not properly measured nor, and in the cross-examination,
No basis for no basis also allowed.
in the cross-examination also, he has taken inconsistent stand. And and there is no basis for the court commissioner to arrive at such conclusion. Next, the trial court by order impugned had allowed,
Accepted the
had accepted the commissioner's report. And the objections raised by both the parties, the plaintiff and defendant number 2, were not considered. And court gives observes that when he has measured the land and he has given a observation, given a report that owners of site number 214 and 216 have encroached 10 feet each in site number 215. And merely because the court commissioner has mentioned the extent of property encroached by the defendants, and merely because the court commissioner has reposed about encroachment made by the defendants and submit the report, the defendants cannot contend that the report of the court commissioner is not in accordance with law. The court observes that the commissioner has measured and demarcated the plain scheduled properties and prepared the sketch-wide exhibit C4 as per order passed by the court. Nothing is elicited in the evidence of CW1 to show that the court commissioner has committed an irregularity or illegality. In the absence of such material, there is no reason the court has to accept the commissioner's report and accordingly accepted the report by order impugned. Then counsel for the plaintiff as well as defendant number 2 have their own objections to the commissioner's report. But ultimately, both of them want the commissioner's report to be rejected and a commissioner be appointed and a fresh survey to be conducted and a report has to be placed before the court. This court and the learned counsels appearing for both the sides had argued on the similar lines. Next para. Having heard the counsels on either side, there is a material on record. The facts of the case are very clear, and all the plaintiff, defendant number 1, defendant number 2 is claiming their right basing on a registered sale deed. And these properties are situated in a layout.
Approved layout.
In an approved layout. For determining the fact, what is the encroachment, the surveyor who has the expertise to deal with it, basing on the surveyor's report, basing on the layout, basing on the sale deeds of the respective parties, there cannot be such an ambiguity. The order of the court that the commissioner's cross-examination and his submission and his and the statement that is made by him in the cross-examination is not relevant, is unsustainable. When the court commissioner has surveyed the land and has placed the report before the court, the defendants have every right to, the parties have every right to cross-examine him, and the commissioner's report and his examination should be on the similar lines. And in this case, it appears that the evidence that is given by him is contrary to the report. And it is a case of the defendants that he has not surveyed the land as per the warrant issued. What is it called?
Memo of instructions.
Memo of instructions. Considering all this court is of the view that the order and impugned needs to be set aside and the matter shall be remanded back to the court. Accordingly, the court is passing the following order. The order dated so-and-so, invoice number so-and-so is set aside and the matter is remanded. Number 2, the court shall appoint a surveyor and shall fix and shall issue specific instructions with regard to the nature of the controversy and what should be what should be measured by the commissioner, and a clear answer to the queries of the court. Next para. This is a suit of 2014, and already now the arguments are already advanced by the parties. The court, after looking at the commissioner's report and after giving a reasonable opportunity to the parties, shall dispose of the case from the date of the commissioner's report within 6 months.
The commissioner has to also answer the instructions given by both the parties. That your
Okay.
lordship may kindly says. Specific instructions given.
What
to-
instruction?
No, we would have given instructions to the court commissioner as
What
to-
instruction?
regarding the identification
Is
of
it
the.
not the court, is it not the duty of the court to fix up what is, how the survey has to be done?
I mean, that is also, normally, the parties also will be given liberty to give memo of instructions to the commissioner as to how the property has to be measured. If there is a,
No. No, that's what, if you tell the court will understand what it is. Now the court will, no, there is a layout plan. And this is the property of the plaintiff defendant. What is the extent of the property from he will measure. Why should you give them instructions? And why do the another litigation on that?
no, ultimately, at least your lordship may say, taking into account the layout plan. Because that is
I
not.
said, The court has, I said, the court has to instruct, basing on the layout plan and
Yes.
further looking at your sale deeds.
Yes.
Court shall fix up the manner in which the commission has to work.
Yes,
Yes. Accordingly disposed of. Next.
Report, Selmanine. Srivatsava HK, public.
Yes. No notice the orders. Huh? Respondents are not served till now. Respondents are not served till now.
No, my lords.
Now, why should, 1 minute, why should the writ petition of 2020, without complying the office objections in 2025, why should we hear it? And what is the purpose of filing the writ petition? When did you file this? You filed it on 18/3/2020.
Yes, my lords.
15/6/2020, put up the matter for additional documents at your request.
We filed the additional list of documents also subsequently.
YA1 of 2020 for production of additional documents. 4/8/2021, none appeared. IA number 1 of 2021 is to file to recall the order dated 23/8/2021. The
23.
cause shown for the default of the petitioner is accepted. Order date, already one recall is over in the year 23 on 25/8/2022. At request, leaves this matter in 2023. Then the first time, after you complying, emergent notice to respondents in the year 2023 in a petition filed in 2020. It appears that the regular appeal out of which the present writ petition arises has been disposed of on 11/3/2022, and therefore the prayer made in the writ petition has become infructuous. Stands disposed of. What is this? There is an order on 14th August 2024. Please look at the court file. Pass over.
Yes.
Yes, next.
Orders matter, number 10,
Petition.
A Balakrishna.
Steps to be taken in respect of unserved proposed R1B.
I pray for a week's time to take out paper publication.
Please do that. It's a petition of 2015. Next, IA number 1, so in filing the LR application. And the notice is ordered in the LR application.
And I was directed to serve the copy on the counsel who is appearing before the court below. I have served,
You
I
have
have
done.
served mine.
Memo is filed in that regard.
I have filed.
Served. Proposed R1A2 so and so served. Basing on that, IA number 1024 is filed to condone the delay of 372 days filing in the, for filing the LR application. Considering the reasons, though no notice is served on the respondents, no representation on their behalf. The delay of so and so, 370 days is condoned, considering the reasons stated in the accompanying affidavit. And accordingly, IN of 1 of 2024 is allowed. Consequently, IA 22 of 2024 to set aside the abatement is also allowed. And so and so are brought on record as LRs of deceased R1A. R1A, and the petitioner shall carry out the necessary amendment to the cost title. Next, in respect of R1B, R1B, the petitioner shall come up with an application for substituted surveys. List this matter when?
Weeks time.
List this matter on today's,
29.
list this matter on 29. Delete from the caption for dismissal. It's not in the dismissal, yes. Yes, one,
Serial number
7.
11. Raghavendra,
Pray for the petitioner.
chief of petitioner.
Pray for weeks time to comply with the officer.
Why?
There is some officer objection raised on the
Oh,
application.
2017, why should the court wait till now?
At least 2 days time I can. I will comply with the officer.
2 days' time.
There are some.
But 2 days'
rectifications.
time is granted for complying with the office objections, or else the writ petition shall stand dismissed without further reference to the court. If the office objections are, it is for service of notice. No, it's only
No,
amended
madam,
cost
amendment,
title.
but there is some office objection, I will rectify it.
All the objections shall be rectified. No, the respondents are served. List, if the office objections are complied with within 2 days, list this matter on Thursday.
Great.
Yes, next.
Serial number 12. Nagaraj is for petitioner.
No representation for dismissal tomorrow.
Serial number 13.
Petitioner placement. Here, several steps have been taken, my lords. And this honorable court had ordered publication also.
That is done.
I have done and I have filed the paper publication before, my lords. Then subsequently, this court had directed me to take notice again to a fresh address.
Not
That-
necessary. When was it taken?
I have filed it on
It is submitted that. As
13
per
8
the orders passed by this
2024.
court, he has already taken out paper publication in
Indian Express, New Delhi edition dated 12/8/2024.
12/8/2024.
And in Veer Arjun Hindi newspaper.
In
Veer Arjun
Veer
Hindi
Arjun
newspaper,
Hindi
both
newspaper,
Delhi, New
and,
Delhi.
The publication is a publication, the same is placed before the court. The later, this court, like the coordinate bench of this court on 28/8/2024 had granted the time for the petition to take fresh summons in the light of the fact that already petition has taken out notice by way of substituted service. The notice in respect of so-and-so holds court, print the name of the parties in the cause list. This is matter tomorrow.
I'm grateful, please.
Yes, next.
Number 14. Serial number 14. Raghavendra SH.
No representation for dismissal tomorrow.
Serial number 15. Serial number 15. Abhinay YT for petitioner, permission of
Same order for dismissal tomorrow. Yes, next.
serial number 16.
Yeah.
Place for weak accommodations to unserved, take steps for unserved respondents.
What about the deceased?
We'll file a necessary application, ma'am.
You
Yes,
will
we-
file or you have already filed?
We'll file, ma'am.
Do whatever you want in a week. If you don't do it,
Please,
it
please,
will be
ma'am.
dismissed.
Please, ma'am.
The petitioner has to take steps in respect of the deceased R4 and R44, and also in respect of deceased R11. And there are several respondents who over unserved as the steps are not taken. The petitioner shall do the needful within a week's time in respect of all the objections, or else the writ petition shall stand dismissed without further reference to the court. Yes,
Case number 17, Sachin BS.
Sorry, my lords, sorry to interrupt. Serial number 15, I was late, my lords. Furnish me with the correct address. I have to take steps in respect of R1BC and
how
R1B.
many times it is?
Fourth.
Fourth time? 15.
15, yes, my lords.
Is it for the first time or which,
First time.
first time?
R1BC and R1BD.
They are the LRs.
LRs of R1B. R1 died. LRs of R1 were brought. R1BC and
15. It is directed to posted for dismissal. Finally, a week's time is granted for taking steps. Same default order.
Okay.
Next,
Case number 17, Sachin BS for petitioner.
For the petition, my lords. 1 week time, my lords, I'll
a
file,
week's time, a week's time,
my lords, interim order may be extended, my
a
lords.
week's time for taking steps. Or else the petition shall stand dismissed without further reference to the court. Interim order earlier granted is extended till then.
Please.
Yes,
18, Case Narayan
no
Swamy.
representation for dismissal tomorrow. Yes.
Case number 19,
For the fourth respondent.
My lord, I prayed time for taking a paper publication, my lord. During the pendency of this petition, writ petition, my lord, the respondent number 1 is died. Only one, his wife, my lord, I will take it already 3 times. I have already taken the steps, my lord. Unfortunately, she is not receiving that.
Then why are you not coming up with the substituted service?
2 days, can you grant 2 days time?
Yes, finally 2 days time is
Submission.
granted. Huh?
One submission I'd like to make. I am the plaintiff, not before the trial court. The order impugned is not on the payment of court fee. So I am the necessary party.
You are not impeded.
Not I am the plaintiff before the trial court.
Oh, you is only concerned with all
I'm
this.
the only concerned party. Not, it is for the court to take a decision whether the court fee is paid sufficient or not. Court says.
Then why the other people are necessary to this application?
My lord,
Cost item?
my lord, I am purchasing the property.
Correct.
was in the
It is
respondent
issue
number
that is,
1.
the issue that is before this court is with regard to the court fees.
Yes, please.
So the court will decide it. And they have, how are all the people necessary and why the 2017 expedition is pending till now? Now let's see who are the parties. Come up with an application. How are they necessary? Plaintiff is before the court.
True,
He is the affected party.
Yes, he filed the application.
Then you file a
My lord,
for dispensation
I-
notice.
I filed the application before the trial court, my lord, order, written statement along with the conversion order. And I filed the application along, filing application, section 11, clause 2 of the Karnataka Suit Valuations Act, my lord. Once his property is converted, he will evaluate the.
Correct. Who will be the affected party by this order?
The plaintiff, my lord.
So he is the only person who is necessary for adjudication of this
Yes,
dispute.
yes, ma'am.
So file a memo for dispensation in respect of other defendants.
My lord, the stepping to show of the respondent number 1, my lord, I am purchasing the property to respondent number 1, my lord. And she is also required to come to the adjudication.
What are you doing from 2017?
No, very recently I filed the application for the court, my lord.
That suit has been stayed.
Petitions of the year 2017.
And through my lord, several times.
You have an interim order in this.
Yes, I have the interim order, my
Of the
lord.
year 1999.
He
has been
stayed.
He stayed, my lord. Reason is, without paying the court fees, my lord, he is taking the advantage of the court. His law, my lord, he paid the court fees, is properly evaluate the suit, my lord. Then only will conduct the case.
Not will be in judgment of this honorable court.
No, my lord.
It cannot be treated as a
that
preliminary issue. It can be
full-
taken up along with the all the other issues.
No,
And at the end of the day, may not when judgment
for
is
the-
rendered.
Now, if once he is entitled for a leave, that would be on the payment of court fees.
Yes, my lord. My lord, kindly.
No, but for that reason, a suit of 99 shouldn't be stayed from 2017 to 25. Who is getting benefited out of it? That is wrong. It can't be. On such a simple issue, why should
so
why
many
should there be a
other-
stay from 17 to 25?
Other defendants are also not receiving the notice, my lord. I'm taken
No,
several
as far
times.
as the court fee is concerned, whoever is there on the file, it doesn't matter. Court will look into it, whether the proper court fee is paid or not. It's the prerogative of the court to look into it and to see that he paid.
I will file the memo, my lord. They are, file the memo for dispensation.
Please do that.
Please, my lord.
Land counsel, the respondent submits that. Which respondent is the plaintiff, Mr. Counsel?
Not
Respondent number 1 submits that The present impugned order is with regard to the court fees, and the only affected party is the plaintiff. And just like that, the defendant is proceeding with the matter, and the entire suit proceedings, the suit of 2006.
1999.
But it appears since 2006.
It has been renumbered after
I-
transfer
A
to
suit
another
of
court.
1999
1999.
is stated, when counsel for the petition submits that, he'll come up with an appropriate application. He'll file a memo to the effect that the notice to other respondent is not necessary.
Please.
List this matter day after tomorrow. Or else, if the memo is not filed, the petition, the writ petition against those respondents will stand dismissed. Yes,
My lord, kindly extend the interim.
extend the
order,
interim order till then.
My lord, take up the matter on first or second of the February. my lord.
Why that, 2nd of February is Sunday.
Third, my lord.
We'll have it on 3rd
Yes.
February.
Kindly extend interim order, my lord.
Yes, interim order earlier granted, is extended till then.
Cell number 20.
Much obliged. I shall file the memo, my lord.
Cell number 20, Ravi HK.
Yes,
For
My lords.
petitioner.
I appear for the petitioner. I'm filing the acknowledgement of having paid the cost.
that is one order. Then what about steps to be taken in respect of the unserved respondent?
My lords, I pray for a short accommodation to file the necessary application. I have to take paper
The
publication.
question is, what was happening from 2017? Why is revision, why a writ petition be pending before this court? Any
My
interim order in this?
No, my lords.
Then it must have become, the suit must have been proceeded. Why should we decide it now?
My lords, we have,
What
it
is
is
it?
not served for 3 times.
We can't help it. That's for you to take steps one after the other. And that's for you to pursue the matter before the court. We can't let these matters be like this. In orders, there are thousands of matters of 2017. Where is that list, Anita? Orders over the pendency of matters. And what is the purpose the petitioner wants to achieve? We don't know. And that too, this order is in Kannada. Even that also, you're not saying about the order also. 914 matters only for orders till 2024.
My lords, I pray for 2 days' time to file the necessary application. We'll undertake
Finally,
paper
Land
publication.
counsel for the petition has filed a memo stating that as per the order taken passed by this court, they have already paid an amount of rupees 5,000. As per the order dated 31/7/2024. And submits that in respect of unserved respondent, they'll come up with the steps, list this matter after
My
2
my lord,
days.
I will file the necessary application to undertake paper
That's what, and it submits that, they'll come up with an application for substitute service, list this within 2 days. If the application is not filed, the petition shall stand dismissed without further reference to the court. If the application is filed, list this matter immediately. And the memo that is filed is taken on record. That's
Yes.
right.
21.
Petitioner in this matter.
Petitioner.
Yes.
I'll take out paper publication to respondents.
And the respondent 1 and 2. I am the plaintiff before the trial
R4D.
court.
What is the IA?
They filed application recall and reopen. That was dismissed at the stage of arguments. They filed application before this petition.
So plaintiff is before this court.
I
why
am
the
the
other parties are
only
necessary?
servant.
File a dismissal petition, we'll hear it.
Yes.
Yes, the land counsel for the respondent submits that when a reopen and recall application is filed by the defendant that came to be dismissed and the plaintiff is the only necessary party and the matter is being dragged on from 2017 and on the ground that the notices are not served on the respondent. Land counsel for the petitioner shall come up with submits that he'll come up with an application, come up with a memo, seeking dispensation of notice to the other respondents. List this matter day after tomorrow and the matter will be heard on the day.
Monday.
Monday, the matter will be heard, not Monday, Tuesday. And it will be heard on that day. Yes, next. 22.
Cell number 22.
Appeal for the petitioner, my lord.
Yes.
Was checking 2 weeks time.
Why?
No, my lords, the early, yeah. To
Yes.
seek instructions from the.
What instructions? No instructions are required. We are looking at what is there in the paper. How much 16:1 post this matter on 17-1. 17-1, or list this matter on 21-1. 25-9, none appears for the petitioners. Call after Dasra vacation. At the request of non-counsel the petitioner, call after 2 weeks. None for the parties, list after 3 weeks. And you have an interim order and enjoying it. It won't even be adjourned by a day. You please argue, I'll decide it.
That's one final chance, maybe.
I'll give you a final chance by tomorrow. This is matter tomorrow. No further adjournment will be granted. And the matter will be heard on the merits of it.
Most of
We'll see. That is not us. Yes,
Cell number 23,
Same, my lord.
same matter tomorrow.
cell number 24,
Yes.
Mr. Murthy.
My lord, in this, order 5 rule 20 IA was filed. The affidavit was sworn in by the petitioner in Mumbai, was not identified. File fresh affidavit of weeks time, my lord.
Why, when is the objection by the office and how many times this matter is coming up before the court? A week's time is granted to do the needful, right from 27/8/2024.
My lord. My lord, 5 rule 20 application has been filed to take steps to take
When
substitute
was it-
service against R1 and R6.
When was it filed?
My lord, 29/2024.
First of all, 2018 petition, substituted service
No,
application
ma'am.
filed.
Petitioner is in
Take
Mumbai
out-
a week's
To
time.
take out, to carry out the office objections, again, another weeks, another several weeks' time. Why
So
should
we have
it be
filed the
granted?
application, the objection is on the affidavit, my lord.
That you should have
It's-
cured it. Why you should come up before the court again? You will be knowing what is the office objection.
Week's time, my lord, I request.
Finally, a week's time is granted for complying with the office objection, or else the petition shall stand dismissed without further reference. If the office objections are cleared, list it immediately.
35, Mukkanappa, SP for
Paper
petition.
petitioner. Lord, regarding R3, my lord, notice has been served, my lord. My lord, I restricted my prayer only respond number 8, my lord. Kindly permit me to take notice for in the paper publication.
What is
Sure.
this, objections on IA number 1 of 23?
My lord, R3 already served, my lord. R3 already served.
So then correct it.
Yes.
We'll pass orders.
Yes.
Anita, give that paper to him, do that application, let him correct it. And we'll call it in the afternoon.
Yes.
Much.
Cell number 26, hearing on application, IA.
For respondents in this.
That's one.
Kindly 2 days time may be granted.
Why?
Appearing to the petitioner, my lords. My lords, there are chances of,
No, you, whatever compromise is there, you work out. 2017-25,
referred to the
you
meeting.
you work out your compromise before the civil court.
Was referred to mediation and mediation has been failed.
That's why, whatever, it can be done before the trial court, not before this court, where an interlocutory application is pending.
Yes, my lords, but there are chances wherein
But
talks
the
with
court is
the,
not interested, court will hear the matter on the merits.
my lords, the TI can be interim order. might
Interim
be
order
ex-
will not be extended. When are you going to argue the matter?
My lords, seniors held up in another court, my lords.
This is matter tomorrow, will be heard finally. The interim order granted is extended.
My lords, we are,
Day after
my
tomorrow.
lords, we are seeking instructions to the client, my lords. We're talking to them. A week's time might be granted, my lords. There are
I will not
chances of-
extend, I'll grant, I'll post this matter in the month of February without extending the
No,
interim
my
order.
lords.
If
there
you
are
want interim order to
chances
be
of-
extended day after tomorrow, let your senior come, or else no.
Please, Lord.
Interim order earlier granted is extended till day after tomorrow. No further adjournments will be granted. Both the advocate for the petition, the respondent shall proceed with the main matter. Next, 27.
Number 27.
Yes, 27, I have filed the IA for recalling, my lord. Earlier, there is an order passed by this honorable court to take steps, my lord, insofar as legal errors is concerned. And within 1 week, otherwise, my lord, there is a preemptive order has been passed, my lord. My lord, by calculations error, my lord, that is 14/6, the time was lapsed. My lord.
Yes, you have filed it right now.
We filed, my lord. In spite of, my lord, it is end on the 14/6/2024, my lord. I have filed on 15/6/2024, my lord. 1 day later, my lord, after that 1 week, my lord. I have filed the applications.
The court said,
Uh.
the counsel for the petitioner shall comply with the office objections by 17/1/2025.
That is I complied. Huh. That I compared. I have given the copy, my lord. The only serving the copy is, my lord. I am served the copy to the advocate Chidan. I served the copy, I produced a memo along with the acknowledgement.
Ready? Your application for the steps?
Please, my lord.
Your application for taking steps is ready?
Yeah, yes, my lord.
Where
It
is
is
it?
already filed in the counter, my lord. Along with the counter, it is filed.
Okay.
Memo
Where is it?
along with the counter, it is put up, my lord. Office objections is overruled by the registry and I served the copy to the advocate.
If that application is put up, please see.
Memo. ನಿನ್ನೆ memo ಹಾಕಿದ್ದೆ. ಮೊನ್ನೆ serve ಮಾಡಿ.
To bring the LRs on record.
Bring the alert on record also. IA was filed in the month of 15/6/2024. I have to file within a 1 week, that is end on, my lord,
I understand.
14/6.
Yes.
I have filed on 15/6, my lord. 1 day, my lord. Yes, yes, yes.
That is only the steps. He has to file the petition within so and so time. If it is not, then the default order is passed. Give it.
Therefore, just for default order was passed.
Yes.
I filed the IA for recalling.
Present petition is filed seeking the. Where is that?
98.
Number? IA number 2024 is filed, seeking to recall the order dated 10/7/2019. Where is that? The order dated
9/8/2024.
A week's time is granted, and the matter was posted before the court on 9/8/2024. And on the day, as no representation, the matter came to be dismissed for default. We submitted that. But there are no latches on the part of the petitioner. And he has been continuously pursuing the matter. Considering the reasons stated, the order dated so and so is set aside, and the petition is restored to file. Next para. The petitioner shall, the LR petition shall be listed before this court by day after tomorrow. Give the date on so and so. And if any office objections, all shall be complied with by that date.
Yes. My lord, meanwhile, my lord, in the last, in 34, my lord, respondent number 34, last week she is died, my lord. I will file the, my lord, necessary, my lord.
Within 2 days, that also you do.
Therefore, my lord, Monday, my lord.
Monday, not Monday, Tuesday,
Yes.
this is matter on Tuesday, by the time, all the steps shall be taken
Yes.
in respect of all the respondents,
Yes.
or else the petition shall stand dismissed without further reference to the court.
28. The Vishal for petitioner.
The petitioner.
Okay,
Respondent number 1 has passed away. I have filed applications to bring the LRs on record.
Notice on IA number 1 of 24,
All the three.
All three I.
yes,
I'm getting.
on all the IS.
Interim order has to be expired.
Interim order, when he died,
2021 he died.
then what are you doing till 2024?
We couldn't find the LRs.
Hmm?
We were unable to find the LRs notice. Now we have found the LRs and we have filed the application notice. There is a delay. Notice.
How did you find now?
Taken instructions from the client. Notice.
It's casually you can't take it. You have an interim order in this, then it will continue forever. And now for the notice, another fiasco has to be done. That's not the way to pursue the matters, and the courts can't be mute spectators to all this. 29.
Till number 29.
The interim order be expired. In 28.
Yes, interim order earlier granted the extended till then.
Okay.
Lord,
29.
in this writ petition, I'm filing a memo saying that, my lord, this writ petition may not be pressed, my lord, with liberty, reserving liberty to the petitioner to raise the grounds, my lord, which are urged in this writ petition. In case, my lord, in the event.
No event. What is event?
No, my lord, the.
That kind of.
the issue involved in this writ petition is now that the trial almost is completed and matter is already set down for arguments. The plaintiff side argument is already over. The issue is relating to the deficit stamp duty and the agreement of sale. Therefore, my lord, prosecuting this writ petition, my lord, at this stage, my lord, will not arise. That is what I said in the memo. Just may kindly go through the memo.
When will you proceed? That cannot be proceeded during another course of trial. You can't do it.
I am not seeking another trial, my lord. In the event, my lord, judges goes against the petitioner. I am the defendant before the trial court, my lord. They are the plaintiffs. At the time of marking the document, my lord, we raised the objection saying that this document is insufficiently stamped and the deficiency stamp duty has to be paid. Trial court will reject our contention that we are challenging this writ petition. But now, at this stage, my lord, it may not necessary, my lord. That is what I said in the memo. May kindly peruse, my lord.
No, it is like this. Once you say that with regard to the admissibility of a document, once a finding is given by the court and it attains finality, then subsequently you can't question on that. Now, what kind of liberty the court will grant you?
What I said in the memo is, my lord, in the event, my lord, defendant, my lord, suffer the decree. Suffer the decree.
If you want to pursue it right now. Will not, either there are two ways, either you argue or I allow you to withdraw. No other findings, liberties will be given.
Normally, my lord, this would, liberty would, my lord.
Maybe, it's for the judge to give. I will not give that. If you want, you argue on the merits of it, or else we will just permit you to withdraw.
Next week, my lord, I will
Yes,
get the
Mr.
instructions.
Smarter next week
Please.
on Wednesday.
Oblige. Yes,
29 months.
please.
Cell preliminary hearing B group, cell number 30. Manohar BK.
For the petitioner,
Petitioner.
Yes,
MB Chandrachud for respondent.
the respondent.
all respondents are served?
Please.
Yes.
It's a suit for declaration of title and permanent injunction, my lords. Declaration and permanent injunction, which has been filed in the year 1992, my lords. The said suit came to be dismissed.
You are the plaintiff?
My lords?
Are you the plaintiff?
No, my lords, I am for the defendant. Said suit came to be dismissed on 30/9/2004, against which the regular appeal has been filed.
That is RA number?
RA number 222 of 2006.
No.
Wherein, my lords, an application came to be filed by the plaintiffs that to withdraw the suit along with an appeal with the liberty to file a fresh suit on the same cause of action, against which I have filed my objections also. The trial court has allowed the application. The impugned order is on
Allowed dated?
1/10/2016, my lords.
What is the reasoning of the court? Let's see. Page number?
My lords, before that, my lords, the lordship may kindly take the application, my lords, that has been filed on page number 52, Annexure D, my lords.
52.
52. In this case, my lords, three major points has to be looked into. And with respect to the application, my lords, they have sought for withdrawal with the liberty to file a fresh suit, also to withdraw the RA, my lords. The affidavit says, I state that my father, the first plaintiff Annayappa and second plaintiff Kalappa, have filed the suit before the trial court in OS number 99 of 92 against defendants for declaration of right of archakaship of Kalgattama idol during their lifetime. After filing of this appeal, the appellants died and we came on record as their legal representatives. The defendants' respondents have filed the written statement by contending that they are also Archak of Kalgattama temple, and they have contended that there are 4 families are performing the puja, including my father, for 12 weeks each in a year of 48 weeks on routine basis. That after contest, the trial court has dismissed the suit of my father by making an observation that the plaintiffs are not alone the Archakas of the said temple. The appellants number 1 and 2 are the rustic villagers and did not know the worldly knowledge. As such, they have filed the suit for declaration against the defendants. The suit ought to have been filed seeking relief of right of Archakaship to perform the puja of the temple on the routine basis, and it is only a formal and technical defect. I state that after filing the above appeal, recently the government has taken the steps to take over the temple to the custody of the Muzari department, and the proceedings are taken place. The Tahsildar Gubi is already taking the amount collected in the hundi of the temple. As such, the Tahsildar and other government officials are supervising the affairs of the temple now.
Before that, According what is stated in this petition is, now this particular temple is notified as a
Mujari.
charitable
Yes, ma'am.
organization. I mean, it's under the government.
Government, yes.
Government has notified it.
Yes.
When the government notifies it with regard to the Archakatvam and other things, who will decide it?
The Assistant Commissioner, my lords, under the Endowments Act.
Cannot be filed even on
Yes,
that
my
count
lord.
also.
On that count alone, the suit has also been dismissed before the trial court, against which they have filed an RA.
Yes, what do you say?
Would not dismiss on that ground. Defendant also entered for Archakship. During the pendency of the suit, this development has been taken place.
In the light of that
Please.
Development that has taken place.
Please.
As per the endowment, when it is falling as a endowment institution.
Please, I have to approach the Assistant Commissioner.
Commissioner, so.
That is what I felt an application.
But you can't say I will seek that it should have been liberty to be given to approach the Assistant Commissioner. Will grant now.
There are two other things, my lords. There are two plaintiffs before the trial court. The application has been filed by a sole plaintiff.
Whatever it is.
If that being so, my lords,
But
Order 23 Rule 1, Surplus 5 clearly mandates
When the.
nothing.
Mr. Kant,
Yes, I'm sorry.
let's not go into those technicalities. When the suit is not, when the jurisdiction of the civil court is barred by a special enactment, no suit can lie before the court.
Yes, ma'am.
Because already the proceedings are pending, whether he asks for the liberty or not, the order that is passed by the court is without jurisdiction, which is known as an eye of law.
Yes, ma'am.
So, let's say, I'll pass an order saying that the plaintiffs are at liberty to pursue their remedies before the endowment department.
My lords,
It is not done. You will ask me kindly take page 61. 61, 61. 18th line from the top.
69.
Oh, 61. Impugned order. 18th line from the top.
1 minute.
The suit suffers from formal and technical defect, and the applicant has to seek the remedy before the Tahsildar or the Assistant Commissioner regarding right of ownership under the Charitable and Religious Endowment Act. Due to the changes occurred in the facts and circumstances after having filing the regular appeal, it is thus necessary to allow the applicant to withdraw the suit, reserving liberty to file a
This
fresh.
is where is the objection. How will you file a fresh suit? You can't.
Not
file
the
a
suit, it is the
So
proceeding.
that we
Please.
will observe, and whatever is now, whether one plaintiff is a party, other plaintiff is not a party, even in that count also, the other plaintiff is at liberty. He can always avail the remedies available to him for the endowment department. Nobody can stop it.
My only submission is this should not be a precedent to the Charity Commission to decide.
No, my only submissions, my lord, there are two major points. When they have filed a suit and after full-fledged trial, they got the dismissal judgment and against which they have filed an RA, and they cannot seek a liberty wherein the entire evidence will go.
Thing will be done. It has to be independently dealt with by the Assistant Commissioner.
Without there being any liberty, my lords, if at all they want to approach, if the limitation applies, my lords, let them do it.
Now.
After a lapse of, my lords,
You will
24
again
years.
say, you will again say before the court that as on the day when the suit was decided, that this institution is not notified. As such, that order passed by the first court is binding. Why should you do that? Don't fight on these technicalities. And they have a liberty, they will go.
My lords, if at all they have the channel, my lords, to going before the assistant.
Will be the Assistant Commissioner or the whoever of the observations of
Yes,
the
my
court,
lords.
that also will record.
My lords, the question, my lords, when they have filed an application, the application has been filed by only the sole plaintiff, my lords. When
Now the liberty is given to the one plaintiff.
lords, by a single person. What the section order for 23 rule 1 surplus 5.
So that is all on the technicalities you are saying.
Yes, my lords.
Now what is, you want the RA court to proceed and pass an order?
My lord, the area has to be dismissed on this sole ground itself, my lords. When the suit itself is not maintainable.
It's not, don't worry, honestly, neither neither you are here or there with all this. Please come. The respondent herein, the present, not respondent, the present petition is filed, agreed by the orders dated, what is the date? 1/10/2016, in area number 222 of 2016 by so and so. The plaintiff had filed a suit seeking a declaration that they are the archakas of the temple, and the said suit came to be dismissed. Against that, an RA is filed. During the pendency of the RA, the said institution is notified as a endowment. It's notified by the government as per the, what is it called? Charitable and Endowment
Charitable
Act.
and endowment.
Mujra institution. Mujra institution.
The act is charitable and endowment act.
As per the Karnataka Charitable and Hindu Endowment Act.
Act, ma'am.
Act. At that point of time, the plaintiff had filed a memo.
Application.
It's happening continuously. You should have some restraint. The as institution is notified as a endowment institution, the respondents have come up with an IA, come up with a memo, an application under Order 23, Rule 13 of the CPP.
Appellants filed an, appellants filed an.
That is the plaintiff.
That's a plaintiff.
Respondent, you should the
No,
respondent.
plaintiffs, the
Please.
plaintiffs have filed an application under Order 23, Rule 13 of the CPC, seeking permission to withdraw the original suit, wherein it is stated that the suit suffers from formal and technical defect, and the applicant has to seek the remedy before the Tehsildar Gubbi or the AC Tumkur regarding the rights of archakaship under Charitable and Religious Endowments Act due to the changes occurred in the facts and circumstances of filing the regular appeal. And hence, they sought for a liberty to withdraw the suit and reserving liberty to file a fresh suit on the same cause of action. It is also the court, and it is a case that the formal and technical defects cannot be cured by way of amendment before the court, and no harm will be caused to the other side. The court, by order impugned allowed the application and observed that the plaintiffs are at liberty to withdraw the suit on also this appeal with a liberty to file the suit on the same cause of action, and no hardship will be caused to the respondents. Then the respondents are at liberty to agitate the grievance before the trial court in the performance of puja at the temple. The court also observes that no doubt the appellants could have filed this application before the trial court at the earliest stage before the appeal, before the appellate court at the earliest stage. But that does not mean that the application should not be entertained, as such a said delay can be condoned by imposing a reasonable cost to compensate the respondents, and accordingly, they were permitted to withdraw on payment of ₹5,000 as cost to the respondents. Then counsel appearing for the respondent defendant submits that the court ought not to have allowed the application. He submits that the court had given them a liberty to file a fresh suit on the same cause of action, which is not permissible. And further, the application is filed by one of the plaintiff when the plaintiffs are two in number. Even on that count also, the court ought not to have allowed the application. Next, then counsel appearing for the respondent plaintiff submits that when the institution is notified as notified under the Karnataka Hindu Charitable and Endowments Act, the civil court will not have the jurisdiction, and then necessarily they have to approach the authorities under the Endowment Act. As such, they have sought for the permission, and the court had rightly granted the permission. This submits that there is no illegality in the said order. Next para. Having heard the learned counsels on either side, peruse the material on record. The undisputed facts in this case are that the institution for respect of which the petitioners are seeking their rights of archakatvam is a notified temple under the Hindu Charitable and Religious Endowments Act. Section so and so of the Act bars the jurisdiction of the civil court. It is, Anita, look at the Act. The section so and so of the Act bars the jurisdiction of the civil court. Now, either the order that's passed by the trial court or the appellate court any order that is likely to be passed is without the jurisdiction. And the technical grounds that are raised by the learned counsel for the defendant, this court is not inclined to go into, as the courts have to look at the substantial interest of both the parties. Whether as per the act, when the defendant, when the plaintiff has when the rights have to be adjudicated by the authorities, they'll always be at liberty. And the civil court at this point of time, even the appellate court cannot adjudicate the dispute. The delay and the fact that one person has filed the application, not both the parties, all these aspects, this court is not inclined to go into. However,
Ma'am, I'm sorry. With respect to the same, my lords, the suit has been filed in the year 92, my lords. After a lapse of 24 years, the application came to be filed. And moreover, my lords, the suit has been dismissed after a full-fledged trial. When there is a negative order, my lords, the lordships before the apex court has clearly said that when you have got a negative judgment, you cannot seek for an liberty to file a fresh suit at the appellate stage. That is
all the facts and circumstances of the case. This court, this particular facts, in view of the fact that it is notified under the Endowment Act, it stands on a different footing. Even for example, you don't ask for it. Court has to say on its own that this court has no jurisdiction to entertain this appeal. Necessarily you have to go before the bar or civil court. So permission or not, because it has no jurisdiction, inherent lack of jurisdiction of the court. Yes. What did you write? This court is not inclined to go into, but at the same time, the relief that is sought is to, the liberty that is sought is to file a fresh suit. Even that also cannot be maintained, as you cannot file a suit, but you can initiate appropriate proceedings before the endowment authorities. In that view of the matter, the order dated so and so is modified. The appellants are permitted to withdraw OS number. The plaintiff is permitted to withdraw OS number 99 of 1992 and also withdraw the appeal with liberty to with the liberty to approach the endowment department with regard to their rights, with their rights to Archakatvam of Kalagattamma temple. Number 2, both the defendants are always at liberty to raise their grounds. As far as the costs that are imposed by the court, this court does not interfere, accordingly disposed of.
Number 31. Govind Rajvel.
For the petition, my lord, I request for 2 weeks time, my lord, senior is unwell.
Yes,
due to
all for your-
throat infection. my lord.
Let's see the docket. Interim order in this. Interim order in this.
Interim order.
And the matter is of the year 2017. What has happened to the suit?
There is an interim order.
Interim order.
Interim order.
There was an interim order that has been extended time to time. The matter is stayed and this is awaiting.
It is not stayed. I'm seeing the proceedings and on that I'm telling. 9/7/2024, no interim order extended. 12/8/2024, no extension. 19/8/2024, no extension. No, no stay. You proceed with the matter. I'll make it clear now.
Please, please.
The learned counsel, the petition seeks time, stating that the senior is unwell. This is a writ petition of 2017. No, the stay as per the initially stay was granted on 27/7/2017. It was extended. It was extended till 21/1. It was extended till 16/2/2022. From 16/2/2022, the interim order is not extended. In that view of the matter, the trial court is at liberty to proceed with the matter. This is matter on March 3rd. Yes.
Number 32. We remit. Petitioner.
Yes. You're ready?
I appeal for response.
You're ready.
Can a short accommodation will be granted?
Why? Then you're not even asking for it. You wanted to ask it after he completes?
No, can you?
What accommodation you want?
2 days.
This is a 2017 matter.
2 days time, my kindly be granted. 2 days time, my kindly.
Pose this matter on.
Could I request the main suit challenging the very decree sought to be executed? Madam, after full-fledged trial, the matter has come to an end, and twice the matter is urgent. The matter, the judgment is posted on 31/1. So, Lordship may kindly accommodate first week of, so that whether it surveys for consideration thereafter.
No, what is, how is it connected?
During the course of execution proceedings, I have filed a
Don't have to consider this application at all. This writ petition, we don't have to consider it. If the suit itself is posted for judgment now, where is, no, we cannot consider, we cannot direct the court to hear this matter, or we can set aside that order. So now, then there is no, we need not hear this matter. When is it posted?
31.
31?
1.
Please come. It is submitted with the learned counsel that the main suit itself is posted for judgment on 31/1/2025. There is no interim order by this court, and the court has proceeded with the matter. At this point of time, this court is not inclined to decide the merits or otherwise of this writ petition. Accordingly, the writ petition is dismissed in the light of the fact that the petition is reserved for judgment. Yes, the main suit is reserved for judgment. Yes, next.
Serial number 33. 33. T. Mudduraj for petitioner. T. CH-20.
Kindly pass over this matter, madam. Kindly pass over this.
Pass over.
Serial number 34. Prasanna Kumar P. for petitioner.
Like to appear,
Satish
Madam,
Chandra-
petitioner. Suit for partition. But your lordship gets a plaint, my lord, at link page 18. Ink page, my lord, 24, my lord, is a suit schedule property.
Yes.
Ink page 24, my lord.
You are the plaintiff in the suit.
I'm sorry, my lord.
You are the plaintiff in the suit.
I'm the plaintiff in the suit.
Suit is for partition.
Partition. Ink page 24, my lord, is the suit schedule properties.
Yes.
In page 24, my lord, your lordship gets. These are, my lord, 3 items, my lord, of the suit schedule property. This, my lord, suit is of the year 2006, still pending. Now, what happens, my lord? I have filed the suit, they enter appearance, my lord, I am cross-examined. They step into the box, my lord, for the defense evidence. I am commencing cross-examination. At the time I commence cross-examination, for the first time they say, no, these properties that you have sought for partition have already been acquired by the BDA and have been allotted alternate sites. That, my lord, is quite the respondent, the defendant,
Defendants
The
say. that
defendants
for-
say the plaintiff, the properties for which you have filed the suit for partition, that property no longer exists, has been acquired by BDA and alternate sites have already been allotted to me.
How can they say?
That's what they said in the cross-examination. I, my lord, immediately made a representation to BDA because BDA, my lord, had proposed acquisition earlier also. I had said, suit is pending, kindly do not make any award or issue any alternate sites or compensation, anything to these defendants because it is joint family property. I also have a share. Until the suit is decided, kindly do not dispense anything. At that stage, my lord, your lordship will come to, my lord, ink page 102. My lord, the BDA, my lord, issues an order sheet endorsement issued by them. No, it is in Kannada. I'll just read out more what it says.
102.
102.
Hmm. Yes.
102, my lord, item number 11.
Hmm.
ಸದರಿ ನಿವೇಶನ ನಂಬರ್ ಅರ್ಜಿದಾರರು ಸದರಿ ನಿವೇಶನ ದಾಖಲೆಗಳನ್ನು ನೀಡಿರುವುದು ಸರಿ ಅಷ್ಟೇ. ಆದರೆ ಶ್ರೀ BT ಶ್ರೀನಿವಾಸ್ ಮಲೋಡ್, ದಟ್ ಈಸ್ ದಿ ಪೆಟಿಷನರ್ ಹಿಯರಿಂಗ್, ಬಿನ್ ಲೇಟ್ ಅಂಚೆ ತಿಮ್ಮಯ್ಯ ಮತ್ತು KR ಮಂಜುನಾಥ್ ಅವರು ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಕೆಂಗೇರಿ ಹೋಬಳಿ ಚಲ್ಲಘಟ್ಟ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 17/4, 18/1 and 18/3 which are my lord the suit schedule properties. ಅದರಲ್ಲಿರುವ OS ನಂಬರ್ 7/12, OS 100/11, OS 1827/2006 ದಾಖಲಾಗಿದ್ದು ನಂತರ ವಜಾಗೊಂಡಿರುತ್ತದೆ. They have made a representation to BDA stating that the suit that was filed by me has been dismissed. And they have, my lord, made a forged, my lord, order sheet. That is, my lord, also I have produced. That your lordship gets, my lord, at ink page 137. Earlier, my lord, I had filed an injunction suit, which I had withdrawn with liberty to file, my lord, partition suit. That, my lord, they have forged at ink page 134, my lord, your lordship gets.
What is the forgery in this?
My lord, your lordship gets 134, my lord.
Submission lordship.
One second. I'll just
Because you're
complete.
coming for the only
One second.
application. You're going for the merit of the.
No, I am telling in what
Origin-
context the application came to be
He
filed.
is going for the original suit.
One
He
second.
filed order.
I am only, my lord,
Order
making
11,
this.
order-
Let him, my lord, let me complete.
Order
I'll, my lord,
11, rule 4.
No, one second.
Interrogatories. That is a
Interrogatories,
question.
the reason why I filed interrogatories, I'm only bringing to the attention of this honorable. Kindly see,
Going
my lord,
for
ink
the
page
merit of the
134.
case.
Sir, 1 second, sir.
Yes.
Ink page 134, my lord, your lordship sees. Lord, on the top, my lord, your lordship sees the OS number, my lord, 1827 of 2006 on ink page 134. Lord, this, my lord, they replace on the next page, on page 136. This is, my lord, given together. At ink page, my lord, 136 is, my lord, a withdrawal memo I had filed in a previous suit. Kindly see, my lord, ink page 136. The present memo filed by plaintiff for permission to withdraw the suit as there is one more for partition in 1820/06 before the second additional civil judge Bangalore Rural Division. Similarly, learned counsel for plaintiff has also argued to that effect. However, the learned counsel for defendants objected and filed objection to the effect that he has no objection to.
What?
This is, my lord, withdrawn. This was, my lord, the withdrawal of that suit. So they forged, my lord, this, and I, my lord, received some alternate sites stating that that suit for partition that I have filed has been dismissed. They have, my lord, forged. The 1827/06, my lord, is the current suit that is pending.
Let's look at it like this. Orders on memo, the order
Yes.
as it is.
Please.
As it is, there is nothing to forge in that.
This order is not from this suit. This order, my lord, your lordships are reading.
No. We are looking at orders on memo.
Please.
And the signature of the judge.
Please.
And everything pertains to the.
Not this suit,
Not
for a
this
different suit.
That is what it is.
That is what it is, but it is tagged along with the first page, my lord, your lordship sees.
So as far as this order is concerned, this order, there is no forging the order.
The order is not forged. This
So,
order is
How it
shown.
is placed, how they understood is a different aspect.
Please.
So that is one. Then when it comes to, they have filed some proceedings in respect of OS 827 or
1827/06, my lord, which is the present suit.
according to you, they made the authorities to believe that this docket sheet of OS 827 or 2005
Six.
was 2006, whatever it
Was
is,
dismissed.
was like as if this is all about the understanding. You can't say any.
No,
forged
now, my
thing.
lord, subsequent developments I'll point out.
No, please come to the
That has, my lord, resulted in a charge sheet. Police have investigated, officials are all, 1 second.
We'll come to the, we'll come. to
Therefore, my lord, now, in the course of cross-examination, I had made, my lord, an application for interrogate.
Let's see that. Where is it?
For that is, my lord, your lordship finds that in page 285. I am not even, my lord, pressing on this. The subsequently developments are much water has flown. 285, my lord, your lordship gets. I have sought for, my lord, details of the alternate sites that have been allotted.
Yes.
Even this, my lord, I'm not pressing now. I request now is, what had happened, my lord, when this was in the year 2017, 2018. What had happened was, because of this, what they had done, they had gone to BDA and said, suit is dismissed, allot us alternate sites. They had been allotted. I had asked the BDA, my lord, for what are the alternate sites awarded them, so that I can amend my schedule in the plaint. BDA had refused.
BDA is a party?
Not in this suit. In the separate representation I had made to BDA, I had said, you please give me details of the alternate sites that have been given to them. In 2018, this is, my lord, much later. So therefore, I had, my lord, made an application for interrogatories in the civil court in the course of cross-examination. What are the alternate sites you have got? You please give me details so that I'll amend my schedule.
According to them, alternative sites, sir, you got the alternative site.
No, I did not get. They say we've got. They say it is not a joint family property, it's my self-acquired property on merits, they say. My case is joint family property. I am also entitled to a share. I need to amend my schedule is what I wanted to do then. Now my submission today before your lordship says, I have now secured, my lord, by the investigation was completed, charge sheet is filed against them. In the course of, my lord, investigation, they have given, my lord, the details of the alternate sites that have been allotted. I have, my lord, produced it before the civil court. Suit is pending.
The ground that the joint family properties, they are entitled for the share.
Sorry, my lord.
The BDA has allotted because your suit is dismissed.
Yeah, on the wrong assumption that suit is dismissed, it was allotted to them.
Please come to the impugned order so that the court will understand.
You know, the impugned order lordship gets, my lord, at 15. May I request your lordship to kindly come to, my lord, last paragraph on ink page 16, my lord. This is, my lord, the finding. Brief order.
Before it's a small order, we'll read from the beginning.
Please. The following interrogatories have been asked by the plaintiff to defendants number 1 and 12. It is objected by the defendant number 12 on the ground that the order in the writ petition referred by the plaintiff and his details are not within the custody of the defendant number 11 and 12, but the BDA has not executed any sale deed and question of producing documents will not arise. BDA admittedly is not disbursing any compensation. Therefore, the question of allotment or compensation does not arise. Hence, prays to reject the request of the plaintiff. Shri LP for plaintiff is present. No representation from defendants number 11 and 12. On going through the above interrogatories and the objections filed by defendant, I am of the considered opinion that either way they can get the documents on the basis of their interrogation itself. Such being the case, delivering it to defendant number 11 and 12 who are opposing it, that they have no details of it, such being the case, no purpose will be served except prolonging the matter having regard to facts and circumstances, as it is also listed in the whole category. Apart from that, it is asked in the cross-examination. Therefore, I find no reason to allow the request of the plaintiff in view of the reason. I am not pressing now. Now, subsequently, charge sheet was filed against them. In the course of investigation, they have given what all alternate sites have been allotted to them, what compensation is awarded to them is given to me. I have brought it to the notice of the court. Suit is now ongoing. Now, my only request is, my lord, suit of the year 2006. Your lordship, my lord, dispose of my writ petition. My lord, direction to the trial court to finish off the suit, my lord, within a year. My lord, I will continue the suit.
Please come.
He is not made a party for the BDA lordship.
Not needed.
Not made a.
Not needed.
No positive order is going to be passed for this court. Agreed with the orders passed and on an application filed under order 11 rule 4 dated what is the date? 29?
10/2018, my lord.
10/2018, invoice number 1827 of 2016, 2006 by so and so. The plaintiff is before this court. The plaintiff has sought for certain interrogatories. It is the case that as for the representation made by the defendants, treating the property as treating that the petitioner had withdrawn the suit, had given alternative signs, alternative land to the defendants in the land acquisition proceedings. The said application came to be dismissed by the court, observing that no purpose will be served except prolonging the matter, having regarding the facts and circumstances of the case, and is also listed in old category. Apart from that, it is asked in the cross-examination. Therefore, there is no reason to allow the request of the plaintiff. When the matter came up for hearing, land counsel the petitioner submits that thereafter, on a criminal complaint made by him, the police have conducted the investigation and filed a charge sheet. In the charge sheet, we came to know about the documents, the alternative sites
And
that are given to the defendants, and thereafter he had taken subsequent steps, and the suit is proceeding. As such, at this point of time, he is not interested to pursue on this IA on the order impugned. However, he submits that the suit is of the year 2006. 2006, and 6 as such, there shall be a direction, there may be a direction to the trial court to dispose of the matter as expeditiously as possible. Land counsel appearing to the respondent submits that all the submissions that are made by the petitioner with regard to the complaint or with regard to the
All contention may be
some representation, some misrepresentation made by the defendant is not necessary for adjudication of the dispute before the court. He submits that now the court is going ahead with the matter. The defendants will raise all the grounds that are available to them before the trial court. Considering the submission of both the parties and the fact that the petitioner is not interested to pursue this IA in view of the subsequent changes that have taken place, this court is passing the following order. This court is not inclined to interfere as the suit is of the year 2006, and now even after the writ petition is filed, the trial court has already proceeded with the matter. Number 2, considering the fact that this is a writ petition of 2006, the court shall dispose of the same as expeditiously as possible, but not later than 6 months.
Kept it open all the.
And it is open for all the parties to have their contentions.
Grateful.
Yes, please.
35. Cell number 35. Nothing. Where Madhusudan Rao.
Plaintiff's petition. Plaintiff's petition. What is challenged is the order passed by the court below regarding valuation. Suit is filed for declaration and injunction, and also with for a relief of mandatory injunction to remove the illegal construction. The court fee was valued as if it is an agricultural. The court below comes to the conclusion that it should have been valued as a not a non-agricultural property.
As per the register, it is a government. It's
And what has
agricultural,
happened, he contended that it's a part of an agricultural property. That's what we had contended.
Not
And-
your contention.
Yes,
For in support of your contention,
what
you must
I've-
place before the court the
Acco-
value. fixed
According,
by the-
yeah, that's what I'm trying to say. What has happened is the defendant has, we have stated in the plaintiff itself, the defendant has contended that, has got this particular portion included in getting the land converted by himself. And we are not bound by it. I don't want to take your lordship's time much. In this case, I do concede. Yes, even assuming that it is stated as a non-agricultural property, if I have to make a fresh valuation. We have, because it's a suit for declaration and injunction, we have to value the suit as per section 24B of the Karnataka Code.
Yes,
Not 24A. What the court below has done is,
view that act.
court below has said, I should value under 24A.
Well, let's see.
That is not correct. In fact, I prepared a
24A says where the prayer is for declaration and for possession of the property.
Yes.
To which the declaration relates.
Yes.
Fee shall be computed.
On the
at
market
value of the property or in rupees or
1,000,
so and so,
whichever
which
is
is earlier, higher.
higher.
Next, second is where the prayer is for a declaration and for consequential injunction, and the relief sought is with reference to any immovable property. Fee shall be computed on 1/2 of the market value of the property.
That is the position. It can't be 24A. 24B is my.
It is true, my lord, 24B, my lord. But they, as per their variation, my lord, they have valued this suit property for 9,50,000.
Whatever it is, let's not go into that. Now we'll
I am
say.
ready to pay.
Now the
on half
there
the
is no
market
dispute that it is a agriculture property. As per the register maintained by the registrar, what is the market value? And as per section 24B, they have to pay the fees.
Please, ma'am.
That's what.
But
we'll-
even the trial court also observed in the para 12 of its impugned order that the defendant has also produced some of the documents
No, that-
regarding the sub-register valuation.
Mm.
Owing to that sub-register valuation, the court has directed to pay the plaintiff on the market value.
No,
ma'am.
it says 24A. It makes a lot of difference.
24A.
24,
We will clarify.
Please.
On the market value of the property, considering it as
that
a
instead of 24, it has to be as
under
24B.
24B.
Because
I
they
have
have
prepared a
sought the
valuation
consequential-
slip. I prepared a memo of valuation, which according to me, my lord, I have to pay.
No, we'll
40
not go into all that. We will say
Let
that
the
it's
trial
a
court decide that on.
non-agriculture land under the it's a non-agriculture land. And you are entitled to pay the fees under 24 B,
B.
but not A.
A.
And accordingly, the court shall direct the
I may be
petitioner.
permitted to file a memo of
Memo
valuation
of
before the trial.
calculation, you will get the liberty to say like
Please,
whether it is.
Please, because according to the plain governments, we have valued at rupees 9,75,000, 9,50,000.
And as per the sub-registrar value, how much it
So
is?
whatever it is, I have valued at 9,50,000.
No, no,
that
what is the value now?
The value is in fact lesser than that, but I want to pay court fee on 9,50,000 only. That is half the market value will be 4,75,000. On 4,75,000, I have to pay court fee.
Please come, agreed with the orders passed on. The preliminary issue number 6 in OS number 1 of 2018 dated 6th December 2018. The plaintiff is before this court. The plaintiff has sought for declaration, recovery of position also.
Declaration, permanent
Mandatory.
injunction.
Declaration
For
and-
mandatory injunction to remove the illegal construction. That's all.
Permanent injunction, and also sought for mandatory injunction to remove the
Illegal
illegal constructions. According to the petitioner, it is a non-agriculture land, and he has assessed the court fee at rupees 9 lakh and paid the. court fee.
9,50,000. No,
The market
according to
value of the
me,
property.
I
at
have
9
stated
lakh.
in the plain that it is an agricultural property, but the court has held I should have
I
valued.
understand that. You have stated in the plain that it is an agricultural land.
Yes.
And the value is 9 lakhs.
Yeah,
And
9,50,000.
accordingly, you paid the court fees as per section 24B of the Court Fees Act.
Yes,
Correct?
yes, ma'am.
24B of the Court Fees Act. When an issue is framed with regard to the court fees as a preliminary issue, the court comes to the conclusion that the plaintiffs are directed to pay the necessary court fee in accordance with section 24A of the Karnataka Court Fee and Suit Valuation Act on the basis of the market value of the suit scheduled properties within 1 month from the date of the order and furnish fresh valuation slip, failing which the suit is ordered to be dismissed as the court fee paid is insufficient. Agreed thereby, the plaintiff is before this court. Land counsel appearing for the plaintiff submits that it is an agricultural property and the defendant has placed some material to show that it is not an agricultural, that it is no more a agriculture property, and the court cannot look into those kind of evidence, and the court fee needs to be paid on as per section 24B of the suit fees and suit fees, the Court Fees and Suit Valuation Act 1958, and but not as per section 24D of A of the Act. All these aspects were not considered by the court. Next, but land counsel for the respondent defendant submits that as per the register maintained by the.
As
by
per
the-
exhibit D1 to D6. ma'am.
As per exhibit,
D1 to D6.
as per exhibit D1 to D6, these properties are non-agriculture lands. And the calculation of the court fee as if the properties, the suit scheduled properties or agriculture properties was rightly considered by the court, and court had rightly directed the plaintiff to pay the court fee as per section 24A of the Karnataka Court Fees Act. Next para. Having heard the counsels on either side, there is a material on record. The suit is for declaration, permanent injunction, and also a mandatory injunction to remove the unauthorized structures. In respect of the section 24 of the Act deals with the court fees in respect of the declaratory suits. And as per, and which reads thus, extract section 24, A and B. In a section 24, the whole section, A to D extract. And as far as immovable properties are concerned, for the declaratory relief section 24B says that it shall be computed on 1/2 of the market value of the property. So when there is a specific provision with regard to the immovable property, court ought not to have directed the petitioner, plaintiff to pay the market fee under 24A. Hence, in the considered opinion of this court, the court fee has to be computed on section 24B of the Act. Then coming to the coming to the agriculture and non-agricultural, whether the property is agriculture or non-agriculture, as per the as per the documents marked on behalf of the defendant, either the properties or non-agricultural properties. In that view of the matter, basing on the value fixed by the value maintained by the registrar, the petitioner plaintiff has to pay has to pay on 1/2 of the market value of the property. In that view of the matter, this court is passing the following order. Number one, the order impugned dated is set aside as far as the computing the market fee on section 24A of the Karnataka Court Fees Act. And the plaintiff shall pay the court fees on section 24 as per section 24B of the Karnataka Court Fee Act number 2. As per the valuation given by the, as per available with the registrar, the market value shall be, and basing on the such market value, the petitioner shall file the valuation slip.
As on the date of the filing of this, as on the date of the filing of.
As on the date of the filing of the suit, and the respondent defendant is at liberty to file his objection. Basing on that, the court shall decide the amount that has to be filed by the, that has to be paid by the plaintiff and fix the court fee accordingly. Yes, next. Petition.
Lord, serial number 31, a short date may be given, my lord, serial number 31.
31,
Please, my lord.
please the matter on 17th of February, on 20, when the date is given?
It's on March, my lord.
March, let it be on 4th of February. Inform the other side also.
5th, my lord, 5th.
5th of February, inform the other
Please,
side.
my lord.
Twenty-seven to the degree, 37.
ಡಿಲೇ ಆಗುತ್ತೆ ಮಕ್ಕಳದು ಮೇಡಮ್ ಒಂದು ಡೇಟ್ ಇದೆಯಾ
ತರ್ಲೆ ತರ ಆಡ್ಬಾರ್ದು ಯಾವತ್ತೂ.
Hello?
Act says so that you have to pay the money also.
That provision does not say anything. That
No.
provision says under
The
third,
reporting will be done just like that.
my lord, section 30-34, the scheme is like,
Please give his file. No, in your case, what is the document?
annexure B, my lord, ink page 16, ink page 16.
16. Hmm.
It's a
What is this
registered document.
Registered document.
And stamp duty, the trial court's finding is wrong, but to a minuscule extent, my lord, because trial court says 6 rupee you have paid. What is paid is 200, but it is nevertheless less. And it says what should have been paid was 8% of the consideration, which was 16,000 rupees.
16,000 rupees.
Yes, my lord.
No.
No.
If a document has to be impounded, what should be the amount? No, on that, the consideration is 16,000.
Consideration is 2 lakh.
2 lakh. Then what would be if the document has to be impounded? What amount needs to be paid?
The stamp duty is 16%, 16,000 rupees,
Okay.
8,000.
Hmm.
And penalty of 10 times. Insofar as the court is concerned, when it goes before the,
How much it comes? No, let us look at it as how it stands.
it is mathematically the trial court's order is correct, my lord. It comes to 1 lakh.
It comes to what amount?
80,000.
So we'll see where is the order of the trial.
Annexure A, 1,76,000. Annexure A is the order, my lord.
Page number.
Once again.
As per on perusal of the suit document, sale agreement dated 11/12, they prepared only 6 rupees document sheet. It was prepared and executed by both the parties for the sale consideration of 2 lakh and same day position of property handed over. As per Article 5 EI of the, no dispute on this also, that Article 5 EI applies to your case. Stamp Act, the duty payable on sale agreement relating to mobile property wherein position is delivered would be same as a conveyance on the market value of the property. As per Article 20 of the Karnataka Sangham, 8% of the market value. So you are not disputing any of the.
I cannot dispute. I cannot.
So only your case is such a power is not vested with the court. Earlier, there is no order passed.
No.
It is the
Document
first
was marked as exhibit.
No, it is already marked. No question of fixing this, all these amounts.
At this
not
stage,
arise.
for that same court.
Hmm.
That court could not have done it.
Hmm.
And therefore the order is bad.
So you're relying on section 35 and section 50?
Section 35 read with section 58.
58.
Section 35, and my lord, I refer to the judgment in Digambarvarti confirmed by Honorable Supreme.
Now, Digambarvarti, which para you are relying on?
Yes, my lord, 1 second. And I gave that another judgment also, my lord. Let me.
Yes, both are there. Digambarvarti and that is followed later in
I can't say followed, my lord. Supreme Court confirmed.
Gangappa and others.
Yes, my lord.
Gammagappa and another.
Yes, my lord. Digambarvarti, para 36.
36.
Para 36. They discuss this aspect.
Let's see again.
Yes, ma'am. This provision, it starts with this provision. That reference is to 34 actually here.
Yes.
This provision refers to power of civil code which admits the documents in evidence. The main section is couched in the negative. Unless the instrument is duly stamped, it is inadmissible in evidence. As an exception, the proviso provides for payment of duty and penalty. In the matter of collection of duty and penalty, no discretion is vested with the authority admitting such an instrument in evidence. The duty payable on the instrument is prescribed by statute. Therefore, there is no question of any discretion being vested with the authority impounding the document in the matter of collecting the duty. Once the duty payable is ascertained from the statute, no discretion is vested with the authority admitting the document in evidence. In the matter of imposition of duty and penalty, the word used in the said proviso is shall. It is mandatory. No, my lord. What I am saying is no. However, section 35 makes it clear that it makes it clear that where an instrument has been admitted in evidence without there being objection at the time of admitting the said instrument in evidence, then such admission shall not, except as provided in section 58, be called in question at any stage of the same suit or proceeding on the ground that the instrument has not been duly stamped. My lord, all that I am saying is there are two, my lord. One is the court does not have power in view of section 35. I read section 35 also, my lord. I can read it again if your lordship sees it once. It says only by virtue, it can only be done as provided under section 58.
She's not going to unmark the document or demark the document.
No, my lord. But I will have to pay so much.
That
Legally supposed to pay, which applies to everybody. A mistake on the part of the court in not doing it. No, anyhow, that is all in the merits of the matter where a document is admitted in evidence on a ground of stamp duty it cannot be altered, and the other judgment also have relied on. The court is on the point that you also admit that it is a deficiently stamped or unstamped, which has to be impounded. As on the day when the document is placed before the court for admission, that is supposed to be the impounded, and impounding charges are so and so, which you conveniently, for whatever reason, cannot be rectified.
Well, two things. One, as I said, if your lordships acts on propriety, I have no leg to stand. I can't argue. I can't say I'm right in morally justifying that.
So the judgment
Two
of the
things.
apex court or the provisions, we cannot, no, they have not visualized these kind of situations. It is only when there is no objection with regard to the admissibility of a document and it is marked, then later they can't turn around and say that document cannot be marked. That is the proposition.
I'll just point out, my lord. What I am trying to do is, I am trying to say, as is there is inadvertence on the part of the court, there is a lapse also on behalf of the plaintiff, because this is a document which is marked in evidence, and your lordship can see that annexure B, in one line in Kannada document, in last sentence, a statement is made that the possession is handed over. It's not even done.
Of these judgments of the apex court, we will not go into that aspect.
I agree.
Neither the court can go,
I
or
agree.
anybody can go. But why should you have the advantage of a document which needs to be impounded, and you don't do it and happily have it?
My lord, why I am saying this, if I
under the inherent powers of the court, can the court can't do it?
There's a
or not?
bar. There is a bar under the act, my lord. When the specific the provision bar says,
Yes, what the provision reads. Again, we'll read.
Yes, my lord, please.
We'll read it.
Yes, ma'am. Section 35. Admission of instrument where not to be questioned. Where instrument has been admitted in evidence, such admission shall not, except as provided in section 58, be called in question at any stage of the same suit or proceeding on the ground that the instrument has not been duly stamped. So, therefore, now, my lord, if we read these concurrently, 33, 34, and 35, unless stamp duty is paid, it could not have been marked. However, if it has already been marked, the marking cannot be brought in question on the ground that it is not stamped. No, my lord, and it's not being remediless, my lord. If your lordship reads 58, no, 35 is clear, except as according with section 58.
Court to look at it. It's for the court to look at whether forget about what the defendant is saying. When a document is marked, when all these facts are admitted facts, why not the revenue be? Why you will be, why you shall be permitted?
For that, let me take your lordship's section 58. Only benefit that I have there is, section 58 says, then the court shall refer it to the deputy commissioner. Before deputy commissioner,
in case 58 will arise, referring it to the registrar, in case of this, what is the market value, any disputes regarding?
No, my lord, may not be correct, my lord.
Let's read it.
I'll read, my lord.
Section 50?
58.
Read it.
1 second, madam. Revision of certain decisions of court regarding sufficiency of stamps. It's not on valuation, my lord. When any court in excess of civil or revenue jurisdiction or any criminal court in any proceeding under chapter so and so of CRPC makes any order admitting any document in evidence as duly stamped or not as requiring stop or upon payment of duty and a penalty on section 34, the court to which appeal lies from or references are made by such first mentioned court may, of its own motion or on the application of the deputy commissioner, take such order into consideration. If such court, after such consideration, is of opinion that such instrument should not have been admitted in evidence without the payment of duty and penalty in section 34, or without the payment of a higher duty and penalty than those paid, it may record a declaration to the effect and determine the amount of duty with which such instrument is chargeable, and may require any person in whose possession of power such instrument then is to produce same and may impound the same when produced. When any declaration has been recorded in subsection 2, the court recording the same shall, I'm on this, my lord, shall send a copy thereof to the deputy commissioner, and where instrument to which it relates has been impounded or is otherwise in the possession of such court, shall also send him such instrument. The Deputy Commissioner may thereupon, notwithstanding anything contained in the order admitting such instrument in evidence or in any certificate granted in 41 or in section, prosecute any person for an offence against supply which the Deputy Commissioner considers him to have committed in respect of such instrument, provided that no such prosecution shall be result instituted where the amount including duty and penalty which according to determination of such court was payable in respect of such instrument under section 34 is paid to Deputy Commissioner unless he thinks that the instrument was committed with an intention of evading stamp duty. Except for the purpose of such prosecution, no declaration made in this section shall affect the validity of any order admitting an instrument in evidence or any certificate granted under section 41. Now, my lord, in view of this, it is very clear that if the court has admitted in evidence and marked it as an exhibit, it is only the appellate court that can do it, either suo motu or on the application of Deputy Commissioner. I understand what your lordship is saying. Therefore, I said, perhaps I'm only trying to take advantage of the situation, unfortunately, because
I'm only trying to
I understand,
see
my lord.
and get over the judgment of the apex court in dismissing your.
I understand that, my lord. That's why I said on day one while arguing also, I said perhaps in terms of propriety, I may not be right in saying, but my lord, the situation in my case is, as I said, my lord, he is a villager and the document is registered. While registering also, stamp duty is not collected. And my lord can see the judgment of Supreme Court in Javerchand that I gave while leaving that day. There, they discuss it very clearly. The court has marked it as an exhibit. After that, it cannot be called in question. And that was the issue in that case particularly.
Please come. This court, WP number 35580/2018 has dismissed the petition. And in the connected matter, yours is serial number?
37, my lord.
On the same day, this court has heard WP number 31814/2019, which arises in the similar circumstances. And similar circumstances. In this court.
I make a submission. There is no such similarity here. Because in my case, the court has exercised the
court
powers.
felt it, the court felt it. That's why it's on a legal issue.
Yes.
An order which is passed, not similar circumstances, legal aspect.
In this case, the document is admitted without collecting anything and there was no any such issue at all.
His case is a better case than your case.
In my case,
Your case is a better case. No, I understood all. So and where the legal issue that falls for consideration before the court is almost one and the same. And the counsel appearing in the second writ petition, that number is WP 31814 has relied on certain decisions. This court had posted the other matter, the first matter for being spoken to. Today, this court has heard both the counsels again. Accordingly, the matter is resolved. The matter is resolved. Both the matters. Order dated so and so is recalled. Yes.
Number 9.
The list is in that item.
I should, I saw it yesterday or day before. There is a single judge judgment on this point again, where they say marking of documents cannot be mechanical. I produce it, it goes against me, but I will not be fair if I don't point it out. That's why.
Please place before.
Give
it to the court office.
I personally do not agree with that because they rely on NN Global, which does not deal with that aspect. But be that as it may, my lord, I'll just
tell the court officer she'll take the print.
It's not reported. I'll just
give the number if it is there.
I'll do that. I'll
Number 9, Srivastava, HK. Petitioner,
Appearing for the petition in this matter.
Yes.
Went through the order sheet. That I think by the 18/9/2004, 14/8/2004 order your lordship was referring.
I'm referring to
14/8/2000.
14/8/2024 order.
Correct, 14/8/2024. The matter is pending, lots, even, I'm not aware how that particular order, this is the order sheet which we got now, right?
On that ground, you want this order to be set aside.
Yes, Lord.
That recording of that, that it is in infractions is not correct.
Correct. So what has happened is that,
The
what
court
it has,
is referring to the RA.
that we have come from the proceedings of the RM, lots, one of the interim order which was passed by the RA, that has been challenged in this writ petition.
As per order dated so and so passed with withdrawn and transferred to Principal Judge Family Court, Chickmangalore. When is this transferred? You're referring to some 2022 order. What has happened after 2022?
No, it is with respect to that, it has been said that it has become infectious.
It is referring to some 11/3/2022.
Yes, Minutes.
So what happened to that matter which is
The
referred?
matter is pending, Minutes.
You have that, you have the docket order of that.
I do not have the docket order. As of now, I do not have, Minutes. I can produce it. This is instantly now we got it online and. took the
Please
print.
come. And what are you going to do now for a writ petition of 2020 arising out of an order?
No, I will, I'll produce the docket sheet, and if your lordship permits me, I will argue the matter, Minutes.
So first of all, notice has to go. That is also not done till now.
I'll take the notice, Minutes.
Huh?
that order was for 14/8.
So that will be recalled. So till now, no notice is ordered.
Notice was ordered, Minutes.
That process is not yet, because in the meantime, that process they have not. filled
When the
in.
matter is pending, what is the difficulty to take out notice on the council?
My apologies, Minutes.
This court by order dated 24th August 2024 had disposed of the matter on as infractions as the RA number 03 of 2018 itself has been disposed of on 11/3/2022. Now an application is filed seeking to recall the order dated 14/8/2024. It is submitted that in fact on 11/3/2022, the matter is transferred to Principal Judge Family Court, Chickmangalore, and the same is pending consideration before the said court. And he has also placed before the court the order dated 11/3/2022, whereby the matter is transferred. Considering the same, the order dated so and so is recalled. Next, the petitioner is permitted to take out notice on the counsel appearing for the respondent, hand summons on the counsel appearing for the respondents before the trial court, and shall file a memo to that effect by 3rd of February. Or else the writ petition itself stands dismissed
Please, Minutes.
without reference to the court. Yes.
Till number 25. 25.
Who sought for it?
That is, that application correction they want.
Yes, he corrected.
They have.
Initially, this court has permitted to take out notice in respect of respondent number 3 and respondent number 8. Then counsel submits that. Now, as notice is already served to respondent number 3, he wants to take notice only in respect of respondent number 4.
8.
Huh?
8.
Respondent number 3 and 8, not 4, 8. And accordingly, the present application is filed. The IA number 1023 is ordered and the petition permitted to take out notice in Karnataka newspaper, Chikbalapur edition, in respect of respondent number 8, on or before,
Or 2.
and shall file and mentioning the date of hearing as so and so. The registry is directed to issue the draft application. Next.
Number 33.
30?
33. See, Mutturaj,
Appearing for the
petitioner, my lord.
Essentially of a respondent.
My lord, this petition has been filed against the dismissal order by the trial court for the application filed under Order 6, Rule 17 for amendment in the plate.
Is dismissed.
Hello?
Is dismissed. Yes. What is the suit for?
Suit for declaration.
Come to the order impugned.
Order impugned.
Page 13.
30?
1-3.
Please read the order. Right from the beginning, small order.
The plaintiff is filed this application under Order 6, Rule 17, seeking to amend the plaint. The defendant number 4 has filed objection to this application at both sides and perused the material on record. The plaintiff has filed the suit seeking for declaration that he is the absolute owner of the suit scheduled property. He has also sought for consequential relief that the judgment and decree passed in OS number 307 of 93 dated 21/3/2007 and execution case number 33 2010 pending do not bus number 307/2010. The plaintiff was brought on record as legal heir of Ravana, the first defendant in OS number 307 of 93. The plaintiff has challenged the maintainability of execution petition, which was overruled on 11/9/2014 by Civil Judge Junior Division and JMFC Magdi. But he has not challenged the said order till date. Even the memo filed by the plaintiff in execution case number 33 of 2010 for deleting his name in the said proceeding was rejected on 21/11/2014, but this order was also not challenged by him. The plaintiff now, by way of filing the application, is seeking to challenge and question the order passed in 33 of 2010 without challenging the order passed in execution 33 of 2010, where the plaintiff is also a party as a JDR 1B. By way of his amendment, the plaintiff is seeking to declare that the order passed in OS number, no, it's a mistake, my lord. It's execution 33 of 2010 and the execution of the sale deed
What is the original relief?
Original relief. The defendant number 4 has claimed as a specific relief.
Specific performance is the relief.
Performance relief. The thing is, the said alleged sale agreement.
When, which year?
It was in 93. Specific.
No, your suit.
My suit is 2015. 2015.
When was the execution filed?
Execution 2010.
2010. And all those two orders which are passed against you were before filing the suit.
No, when execution was pending,
that execution they filed
was pending,
which are prior to filing of your suit.
Yes.
And now, when was this amendment filed?
Amendment was filed on application.
13/1/2016. 13/1/2016. 16.
Already another court has held that you are a proper and necessary party to the execution. You are contesting those matters. You have not questioned any of the orders that are passed by the court.
No, my lord. Here, the crux of the case is that I have got a partition of my property under OS 88 of 1980. Under that, I got this property. My father has received his share and my brothers have received their share. My share has also been got.
The suit for specific performance.
Yes, I am not a party to that suit.
No, earlier the suit was a
Yes.
The suit for declaration.
Yes. Mine is suit for declaration.
And you are a party to the original suit as well as the execution proceeding.
No, execution. Only I was brought in as a necessary party in execution at the time of execution, not in the original suit. Because
so, what all you wanted to say that you have already stated before the executing court that you are not a part, that is not binding and all, and you cannot be a party. And court has passed an order that all order is unchallenged. You keep quiet. After some time, you file a suit. Even at the time of filing the suit, also nothing has been taken. Whether right or wrong is a different issue. No, after that, you come up with this finding, with this application.
My lord, here what happens? the sale agreement which was got executed without my signature in that. I'm not a party to that sale agreement also. My father and brothers have executed that sale agreement, which defendant, defendant number 4 has got through specific performance. But at the time of executing that sale agreement, this partition suit which was filed was pending, and my partition order came to be ordered on 11/10/1989, and the said sale agreement what the defendant number 4 has filed for specific performance was executed on 22/6/1989 prior to the order of the partition in OS 88 of 1980. In OS 88 of 1980, I have got my property partition in my name. That is also in this suit they have
All
claimed.
those things will be decided by the court in the execution that's filed by them. Why should there be an amendment to your suit which is unconnected with that?
It was, the thing is that
Because you are kept quiet, which you are not questioned, know that to fill up those latches, you want to have this amendment.
no, when I was brought in as a necessary party in execution,
What said you are necessary part?
in execution, I was brought in as necessary party, not in OS.
Have been questioned.
Yeah, I question. I have also stated that I am not the necessary party to the execution because I have got my share already.
That was negatived by the court by
Yes.
rejecting your application.
Yes, ma'am.
That you are not questioned, that you want to fill up it by this.
No, I have filed the declaration because on the basis of my partition only, because my share, whatever they have got.
It will be decided by the court about your declaration. Why should the court say that?
No, my lord, my prayer, because what happens, execution, whatever I have challenged as not binding in my OS,
Limitation.
my prayer was that whatever the execution proceedings will not be binding, that got effect only after filing this OS suit. My declaration suit was filed first, then only execution for sale deed, execution of sale deed was ordered.
No, at the time of, Mr. Counsel, at the time of allowing an application for amendment.
Yes.
What are the parameters to be considered? The courts cannot look into the merits of it.
Definitely not.
And at what stage it is filed also has to be looked into.
Definitely.
No, ultimately.
Yes.
He was not a party to the original decree.
He was not a party.
He was made in the execution, you implemented him. No, the decree, no, by virtue of this, making him a party and other things. With respect of the very same property, which is not a party.
No.
What is the difficulty in, what is wrong
At this
in?
point, I don't know whether I can take my lordships to page 23 minutes, I'm sorry. The amendment application at 29. Not the relief what they have sought for is what precisely my lordships asked previously. If not, they're trying to annul the orders passed by the executing court in another suit. That may not be permissible, my lords, because that
Only said,
yes,
only, no, suit is in respect of a particular property.
absolutely.
In respect of it, already there is a judgment and decree.
Yes.
For which he is not a party. No, it's not execution. I'm saying about the judgment and decree.
Not a party to the judgment and
Not a
decree.
party.
He is
Now, in respect to the property, when he has filed a suit, can't he seek a declaration that the judgment is not binding on?
Had he not been a party to.
But still, the judgment and decree won't be altered, he being in a party.
No, the execution satisfaction with it shall be determined by the court executing the decree and not by a separate suit. And not by a separate suit. This is the bar. And not by a separate suit. Now, my lord, it is exactly in court. If my lordship could read the amendment, my lords,
He has not filed a petition under 47.
no, I am pointing out not 47 mandates. Going further, not the Supreme Court explains here that these are questions which have to be decided only in the executing court and none else. There cannot be.
At the same time, there are certain questions which cannot be decided by the executing court, which are already finally attained finality by the.
So, my lords, he has come. That is what I wanted to point out. He is not there all by himself. His father executes the agreement of sale, my lords, in my favor. This is, my lords, prior to the decree what they obtained there.
Whether the father has a right to execute a sale.
Yes, my lords, that is what
in your favor.
that is a
without the signature or concurrence of a
Yes,
joint
Lord.
family member.
Because my lords, that was not the, my lords, kindly see, my lords, that is executed prior to the suit for partition. And my lords, these questions were dealt by the executing court where he filed that application before the executing court. And the executing court, my lords, annulled the same, saying that the agreement had to be the agreement had to be given effect, and my lords, consequently, my lords, the right of the purchaser, that is the vendee in the agreement of sale, my lords, had to be upheld. And what is sought to be questioned, my lords, is not the agreement here. Kindly see, my lords, what is sought to be questioned is not the agreement. What is sought to be questioned, my lords, is an order passed by the executing court, my lords, directing the sale deed to be executed in favor of me. This is exactly what could not have been.
In a way, it amounts to questioning the main judgment and decree.
That is absolutely not what I wanted to point out. Not. They are trying, if they intend to question the judgment and decree, they have to do it only under section 47. This is what the Supreme Court has said. They cannot come back and file another suit because that would tantamount to constructive res judicata.
So in all the cases, wherever somebody is asking for saying that a particular judgment and decree is not binding on them, so such a suits are
As long as they're not parties to the execution.
no, that would be decided eventually.
Correct, not. For instance, I'll just split it up.
What about
Yes,
that part? That is
yes,
another aspect. That's on the legality on the merits of the matter.
Yes,
when an application is decided, when an IA is filed under Order 6, Rule 17,
please.
what are the parameters?
No, the parameters are quite simple. Whether the amendment is required for the actual adjudication of this. There's also another parameter, whether the amendment sought to be projected or inserted to the plane is barred by some other law. Because I put it this way, what is sought to be achieved, what cannot be achieved directly, cannot be achieved.
He is seeking a declaration.
Declaration.
So according to you, he is aware of, he is made a party in the year 2010. This IA is filed in 2016. Seeking a declaration that limitation 12 years.
2010, he is made as a party.
For the first time,
Please.
even according to you, that's me.
Yes, so I'll just point out the remedies what the person has once he has been made as a party to an execution and where his right is affected. One such remedy, my lord says, he can come before your lordships, file an. I'll just point out what is wrong with the current suit for declaration. One, he can come before your lordships, file an appeal by seeking a leave saying that my property right is being affected. 96 is open. They did not avail that remedy. They did not avail that remedy.
This
Then
is the only
they file
property involved in the suit.
Minutes.
This is the only property involved in the suit.
In the partition suit, no, but in the suit for specific performance, it is. It is a collusive setup, within the family. After the decree has been awarded in my favor, in 2015, yet another suit is passed. For almost 20 years, we prosecute the suit for specific performance. Decree is granted. Then, after 2 decades, I put it this way, after 2 decades, 1 year, a suit for declaration is filed by the son. Now, he might have a right, stating he has been allotted the same property in a suit for FDP. Now, I'm just pointing it out. I am not on the merits of the suit at all. I am not on the merits of the suit. What has the mischief what is sought to be achieved by the current amendment says.
Whether can it be looked into in an application under Order 6 Rule 17?
Yes,
whether it is barred by any other law also will not apply to that because his relief.
I'll just put it in this way, I'll just put it in this way. A pleading.
I can understand.
A relevant.
Ultimately,
every pleading has to be relevant for the purpose of allowing the amendment.
Order 6 Rule 17, the parameters are very limited. Under which parameter it comes?
I'll just point. Ultimately, this is something where if a pleading sought to be inserted, demonstrates mischief where they're trying to abuse the process of law, then such an amendment cannot be permitted. Such an amendment cannot be permitted. Why I point out this says the bars in the current case are innumerous. I'll just point out
Plaintiff can have whatever the relief he wants.
Definitely.
For example,
Yes, ma'am.
along with the filing of the suit,
Yes.
he would have sought for all the reliefs.
Yes.
Will it be now non-suited? The court will decide whether such a relief can be granted to him or
7
not.
Rule 11. 7 Rule 11.
I'm saying.
That's an option available to us.
That is now also you have a remedy.
That's an option available to us.
The court will decide whether eventually whether he is entitled for that relief
Correct.
or not.
Correct.
Now, that's why while considering application order 7 rule, order 6 rule 17,
Please, ma'am.
the parameters are like
Limitation.
whether it has been, whether it is filed after the commencement of the trial
Correct.
or whether it is hit by
Correct.
any is by judicata
Correct.
or any other law of limitation. Those
Correct.
things we will look into.
Absolutely. Absolutely.
We will not permit him by way of an amendment to introduce a case which otherwise by way of law, by any other law is barred. No, according to you, years like 2014 is the, 2010 is implemented.
If amendment application, para 1 minutes, I have no issues. It's only with respect to para 2 and 3.
What is para 2 and 3?
Para 2 states this. I shall read it in Kannada so that I can translate for my lordship.
English
ಇದೆಯಾ?
ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೆ.
ಇಲ್ಲ,
ಕೊಟ್ಟಿದ್ದೆ
ಇದ್ರೆ.
ಸಾಹೇಬ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೆ.
ಈ ದಾವೆಯ ವಾದಪತ್ರದ ಪ್ಯಾರ 11ರ ನಂತರ ಪ್ಯಾರ 11 ಇದೆ. ವಾದಿ ಮುಂದುವರೆದು ಹೇಳಿದ್ರು ಅಂದ್ರೆ the plaintiff submits that ಯಾವ ತಪಶೀಲ್ ಆಸ್ತಿಯ ಸರ್ವೆ ನಂಬರ್ 73ರ
ನೆಕ್ಸ್ಟ್ ಅಯ್ಯ.
The plaintiff further submits that
English version is.
yes, the suit schedule property bearing survey number 73, the court defendant has executed a disputed sale deed dated 30/10/2015 before the court commissioner. I'm sorry, the translation is inaccurate.
Okay.
The translation is inaccurate. The fourth defendant has executed a purported sale, minus 1. ಸರ್ವೆ ನಂಬರ್ 73ರ ಬಗ್ಗೆ ವಾದಿಗೆ ಸೇರಿದ ದಾವಾ ಸ್ವತ್ತನ್ನು ಸೇರಿಸಿಕೊಂಡು ಈ ದಾವೆಯ 4ನೇ ಪ್ರತಿವಾದಿ ದಿನಾಂಕ 30/10/2015 ವಿವಾದಾತ್ಮಕ ಕ್ರಯಪತ್ರವನ್ನು ನ್ಯಾಯಾಲಯದ ನಿಯೋಗಿ ಮಧ್ಯಂತರ ಬರೆಸಿ ನೋಂದಾಯಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. The defendant number 1 using the process of court has created fraudulent sale deed dated 30/10/2015 that is executed to the court commissioner. ಸದರಿ ವಿವಾದಾತ್ಮಕ ಕ್ರಯಪತ್ರ ವಾದಿಗೆ ದಾವಾ ಆಸ್ತಿಯ ಮೇಲೆ ಇರುವ ಹಕ್ಕಿಗೆ ಚ್ಯುತಿ ಉಂಟು ಮಾಡತಕ್ಕದ್ದಲ್ಲ ಮತ್ತು ಬಾಧಕವನ್ನು ಉಂಟು ಮಾಡತಕ್ಕದ್ದಲ್ಲ. ವಾದಿಗೆ ಸೇರಿದ ದಾವಾ ಸ್ವತ್ತನ್ನು ಒಳಗೊಂಡಂತೆ ರಾಮನಗರ ಜಿಲ್ಲೆ ಮಾಗಡಿ ತಾಲೂಕು ಸೋಲೂರು ಹುಬ್ಳಿ ಕನ್ನಸಂದ್ರ ಗ್ರಾಮದ ಸರ್ವೆ 74ರಲ್ಲಿ 4 ಎಕರೆ 20 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣ ಸ್ವತ್ತನ್ನು ನ್ಯಾಯಾಲಯದ ನಿಯೋಗಿ ಮೂಲಕ ನೋಂದಣಿ ಮಾಡಿಸಿಕೊಳ್ಳುವ ಅಧಿಕಾರ 4ನೇ ಪ್ರತಿವಾದಿಗೆ ಇರಲಿಲ್ಲ. The last part of it, if I could just translate for my lordships, it reads thus. But it says, the defendant number 4 did not have any manner of right, title or interest to have the sale deed dated 30/10/2015 to have the same executed through the process of court. It reads thus, but ultimately, defendant has got a sale deed through the court commissioner which is dated 30/10/2014, and ultimately it ends thus stating that the defendant has abused the process of law there and he did not have a right, and he has created the sale deed through the process of court, and ultimately he seeks a relief in the prayer column that is at page 30 of the writ petition, which reads thus that the sale deed dated so and so executed through the commission of court does not bind the right, title or interest of the plaintiff thereto. This is the innocuous amendment what is sought to be inserted at para 3 of the amendment application. My submission should be on 3 counts. I will assume in an execution minutes, it operates in 2 parts. I will assume I am a stranger to the execution proceeding. I am a stranger to the proceeding, and someone makes me a party or my property is sought to be invaded by virtue of a decree which is unconcerned to me. Remedy open is 21 Rule 97 to 100, and that is a self-contained remedy where the court will treat the said application, hold an inquiry akin to a suit till 106 minutes. The provision of CPC is self-contained, that if I am a stranger and I am sought to be implemented in execution minutes, the remedy is 97 to 106. I will be treated as an objector. The objector will raise a plea. I am in possession of the property. My possession is independent of the judgment data, and hence an inquiry has to be held. And that will be treated as a suit, and there will be a regular appeal as against the same, or a regular first appeal in
You are
case of
not
right.
agreed with that declaration that he has sought.
Yes, my lord.
Where you are a party, that according to you, that relief is maintainable.
I'm sorry, I couldn't.
He sought a declaration that he is the owner of the property.
He sought a declaration.
He's
He is the owner of
contesting
the
the other
property.
earlier suit. You have to understand.
Please, my lord, please, please.
What is permissible by the petitioner
Please.
while filing the plaint, while
Please.
filing the suit?
Yes, I got your lordship's question. I got your lordship's what has been put across. Your lordships are telling me, what could you have done if the same was incorporated in the plaint while it was presented?
Same thing you would be doing now.
Yes, yes. This is exactly what your lordships are saying. Lords, kindly see, in such circumstances, Lords, where a very similar party, Lords, would have filed a case of this nature. Lords, the judge would have exercised powers under Order 10 at the date of first hearing itself. Because, Lords, what I'm trying to...
You understand in how many cases, the moment the plaint is filed, the judge would be exercising discretion in that.
That is that Arvinda Nadam
What are they
versus
doing?
Satya
The
Paul.
moment
The
the moment the suit is filed,
Yes,
looking at the main relevant portion,
Correct,
the
correct.
notice will be ordered.
Notice will be
You
ordered.
will come.
And the moment
You will
yes,
come, you
yes,
will come. You will question the amendment on the question, on the so and so. Order
it is
7.
barred by law or it is.
That you will see.
Yes, the rejection of claim.
If such an order is passed by the court, this court would be entertaining. What
Correct.
is on the merits of it?
I'll just put it in this way. What has happened now?
I see that no suit is maintainable. If it is barred by limitation, then it's fine. No, it's not barred by limitation.
No, it is not.
You
It
are
is
other technicalities.
no, no, it is barred by the.
What limitation?
No, I'll just point out what limit.
Limitation is
Yes,
seeking a declaration.
Please,
For any
I'll just point out why in that.
No, declaratory relief, 12 years is a limitation.
Please,
He was impleaded and according to you, he was made a party in 2010.
yes, may just put it
2010,
in
this is 2016.
I'll just put it in this way. Not if there's a decree operating, not affecting one's right, title, or interest directly, indirectly. Not the aspect of limitation, not to challenge the same, undo the same, annul the same, not just 3 years. And not the law on the point of decrees as distinguishable from instruments, not has been laid down by the apex court in Durandar Prasad versus Jayaprakash University. Substratum of that is this. Not a instrument, not if it is
Again,
void.
you are entering into the merits of it.
No minutes. If your lordship feel I'm.
So the settled law with the Honorable Apex Court,
Yes,
that while allowing an amendment, you shouldn't look at the merits of the matter and how it is.
Not to the merits of the facts.
No, it is for the party who has instituted the
Yes,
suit
madam.
to seek
Yes,
whatever reliefs you want.
Yes, madam.
It
Yes.
is for the court to consider and
Yes,
grant
madam.
it.
Yes,
Now, first of all, when is a suit filed? When is the relief that is sought? Whether it is as per Order 6, Rule 17, after the trial has commenced, unless and until he prays the court that in spite of due
No,
diligence.
sir, I will not.
That aspect would not
Insofar as
count.
I am concerned, I'll just put it in this way. If there is a material amendment, though it may be post-trial minutes, I will not insist that the language of Order 6, Rule 17 should be strictly followed. No, I will not. I will not. I will not, because amendments minutes are necessary.
Whether the petitioner has a remedy to file an application under Section 47.
Yes.
Or this would be decided by the court on an application filed by you.
Yes.
Not at the stage of Order 6.
I'll just point out, your lordships are absolutely right in saying that. What happens if I
I'll record all this and it is always left open to the defendant to file an appropriate application.
Please,
and the court will
I'll
consider
just
it.
only point out 2 things from the CPC. I'm sure your lordships will come across this on a day-to-day basis. Kindly see minutes for one moment. Order 21. If my lordship could just go to Order 21 for a moment.
Yes, I understand. Order
Minutes,
21.
one moment, not only one moment. Now, minutes, this is an order what is sought to be challenged.
Once this amendment is on record.
Yes, ma'am, yes.
Will be in a better position.
Absolutely understand. Minutes. Now, this suit, I'll point out minutes, how these suits are filed. Innocuous suits, minutes claiming rights on property are filed. Then minutes, what happens minutes in the course of the trial is such amendments minutes are pierced one after the other minutes to undo minutes decrees which are decades together old. Now minutes 2010 minutes he comes to know there is a illegal decree or a illegal judgment. It is not challenged so far. Now minutes I ask myself a question. If there's a judgment and decree which affects him, minutes the law on limitation minutes is the residuary provision. It says 3 years from the date of knowledge. That has not been challenged so far. The judgment binds.
No, Then where is your ILX? You're agitating so many issues.
Yes,
Let's
Lord.
see your objection.
Let's see, objections are at addition E, my lord.
Page number
I'm 33.
33. Please tell the court what are that you have raised.
Minutes, sir. 33. Para 6 there.
Read.
Para 6 there.
See, the ground that is given by the court, nothing what all you are stating before the court with
Yes,
regard to the maintainability.
Section 11 CPC. Res judicata.
Is a res judicata can it be decided now?
Not sir.
Which cannot be decided in an order 7 rule 11 at the preliminary.
Not in so far executions are concerned, not the judgment is covering the field. If I could just take my notion to para 5.
Yes, you sure?
I'll just point out to para 5. Pradeep,
Yes.
please not. A bare perusal of the aforesaid provision shows that all questions between parties can be decided by the executing court. But the important aspect to remember is that these questions are limited to execution.
Precisely, this is what I'm saying.
Yes, yes.
The executing.
Execution of the decree.
The executing court cannot go beyond the decree.
Correct, correct. Might I just quote? Executing court can never go behind the decree. Under section 47, the executing court cannot examine the validity of the order of the court which had allowed the execution of the decree in 2013 unless the court's order is itself without jurisdiction. More importantly, this order was never challenged by the tenants or judgment debtors before any forum. The multiple stages of a civil suit invariably has to go through before it reaches finality is to ensure that any error in law is cured by a high court. The appellate court, the second appellate court, and revisional court do not have the same powers as the powers of the executing court, which are extremely limited. This was explained by Durandar Prasad.
Some judgments are cited.
Yes, please. Then what the validity? Let's kindly see minutes. This is what I wanted to point out for a moment. Durandar Prasad minutes. That second half of that judgment there. The validity or otherwise of a decree may be challenged by filing a properly constituted suit or taking any remedy available under law on the ground that the original defendant had absented himself from proceeding of the suit.
Please come to that page number 14. On the top of it, the page numbers are there.
I'm sorry, that is, I don't think it is right. All right.
14.
14.
That's only what you have given. Top of it, you have the numbers.
Please, minutes.
As you have already referred above.
Yes, might I take my lordship to that place where it says section 47 CPC and after that in page 14. Your lordships are there at page 14.
Page
14.
1-4.
Yes.
The line begins with section 47 CPC.
Yes.
It was submitted by decree holder before the High Court that the order dated so and so had attained finality and res judicata would apply against the judgment. In support of this submission, decree holder relied on decision in Barkat Ali versus Badrinarayan, where this court reiterated settled position of law that principles of res judicata are not only applicable in respect of separate proceedings, but general principles of res judicata are also applicable at subsequent stage of the same proceedings. And therefore, the same court will be precluded to go into that question which has already been decided or deemed to have been decided by it in an earlier stage. In other words, it will be barred by principles of res judicata or at least by the principle of constructive res judicata. Logic here is that an execution proceeding works in different stages and judgment debtors have failed to take an objection and have allowed the preliminary stage to come to an end. Matter has moved on to the next stage. The judgment debtors cannot raise the objection subsequently and revert back to an earlier stage of the proceeding. This is exactly one of the reasons given by the executing court in its order dated so and so, which we have already referred about. Merely because it was not specifically referred to the principle of res judicata, it will not make any difference. It will not make any difference. So the fact not that the aspect of decree minutes is now sought to be challenged separately, not to constitute res judicata because minutes it is also the same court which was also handling the executory proceeding subject to correction.
Well, the court decided that application order 670.
Minutes, sir. Minutes, I am not.
Question of fact and law which cannot be decided.
Minutes, I am not for a moment saying that res judicata.
All these grounds were not at all, except that
section
ground.
Yes, section.
You have not raised any other.
Section 11. Then minutes.
Leave it open to you to decide all.
Can I only not pursue your lordships one other position of law? What's the right of a stranger to a decree? My lordship knows that. Pradeep Ved Kumar. The para 10 to 13 minutes would be the only relevant questions. Where the court notes in para 11, if I could just point out. We would be militating, the crux of my submission, Manoj, we would be militating the provisions of order 97 to 106 of order 21. In Brahmdev Chaudhary versus Rishikesh, this court has observed that order 21 CPC, based on a complete code for resolving all disputes pertaining to execution of decree or possession obtained by the decree holder and whose attempts in the executing code of the said decree met with rough weather, referring to its earlier judgment in Banwarlal versus Satnarayan.
Simple point, what is not objectionable to you?
Yes,
for filing your original suit cannot be an objection for the amendment, because even by way of original relief also, is seeking that he is the owner of the property, wherein all these things will fall into question. And incidentally, you have a decree in your favor.
Correct.
Unless and until that is decided by the court, this
Correct.
cannot be decided.
The fact of the matter, Manoj, is an order even directing an execution of the sale deed, Manoj, falling within order 21. It's a revisible order. That having not been challenged, Manoj, that cannot be resorted to a separate suit. Manoj, that is what the trial court observed, that he was made as a party, he sought for deletion.
We are only, Mr. Counsel, we
Yes.
have so many other remedies. We are only on a function of order 6, rule 17, and within the four corners and the purview the courts have, that only can be decided. I will set aside this order, I will allow the amendment, and I leave it open to you to agitate all the grounds
Very well.
under any of the application that you can file.
Please, Manoj. So,
Yes. I'll record all the judgments which are aligned.
only last two indulgences, Manoj, while your lordship may pass the order. My plea, Manoj, is such liberties, Manoj, available to parties under 105 be reserved. One, the question, Manoj, of limitation and alternative remedies, which that is the bar under section 47 and order 21 rule, be I may be allowed to treat them, not submit them as preliminary objections. So that Manoj, it should not be heard, taken as that.
Yes.
Please.
Agreed with the orders passed in I number 3 in OS number 304 of 2015 dated 10/10.
Yes.
Yes.
Dated 10/10/2018. The defendant is before this court. The plaintiff has initially sought for a declaration and
Declaration.
Consequential.
Consequential.
a consequential injunction. The suit is filed in the year 2015.
Declaration and the declaration that the decree does not,
No, initially.
initially declaration that the decree does not bind him.
Both the execution
And
Uh,
case and
Sought for a declaration that the suit that is to declare that is the owner of the property, and the judgment and decree dated
21/3/2007 in 307 of 1993.
21/3/2007.
In OS number
Number
307 of 1993.
307 of 1993 is not binding on them, on the plaintiff. Thereafter, the present application came to the
No, my
file.
lord, there, while the execution petition was pending itself, I have filed this suit.
Then
In that,
the-
I have prayed that also, that 30, whatever the order.
After the petitioner has come up with an application under order 6 rule 17, stating that the execution proceedings are not binding on the petitioner. That's a relief.
No. In the OS suit, whatever I have filed in
That-
declaration,
no, no, no.
first prayer is.
Whatever your lordship said, that is also included in prayer.
Yes.
But
Second,
that's what I'm saying, in the
Yes.
first order,
First one.
what I sought, again, he sought for the same. That's why I'm taking a distinction
Yes,
between the
yes,
two.
your lordships are right. So he sought for the not binding of judgment and decree, not binding of the.
That is the
execution
second relief he sought.
Yes,
The original suit is filed,
yes.
seeking a declaration that he is owner of the property and also a consequential injunction. Thereafter, by way of this IA, he sought an amendment that the judgment and decree that is passed, you have already written the number, invoice number so and so, is not binding, and also the execution proceedings. and all-
execution order.
The order passed in the execution,
Pending. Next application.
which one is correct?
No, my lord, I would like to clarify
Come to
there.
the IA.
Well, there are two prayers in the OS suit.
Please come to the IA instead of all this
IA,
confusion.
yeah,
Where is it?
29.
All this is in Kannada.
Yes, my lord. I have given the.
The translation is not quite so accurate, so we'll have to redo that. exercise.
Only thing, that whatever the order in execution petition in 33 of 2010 dated 30/10/2015,
And the order passed in execution dated
30/10/2015
30/10/2015
is not
is not binding on him. Now, what I'll do is, as far as the judgment and decree is concerned, that prayer you are allowed to. As far as the other one is concerned, you have you have already, an order is passed, that has to be, you're a party, it has to be independently questioned by you. So your amendment as far as the judgment and decree is concerned will be allowed. As far as that order is concerned, that will go. What is that?
because there is a sale deed getting executed, my lord. That's why once the sale deed executed, that has to be not binding on me, on my property.
Because you're a party to that.
Yes.
You could, what is the remedy when an order is passed?
I filed the objections that I am not I am not the party to OS.
Court has passed an order. Who stopped you from questioning it?
Yes, my lord.
That you do it.
yeah.
What is that? Binding on the petitioner defendant. When an IA is filed under order 6 rule 17, the court had, the defendant had raised his objection stating that this is barred by res judicata and such a prayer cannot be allowed. The court had dismissed the application, observing that the petitioner plaintiff had failed to question the order that is passed in execution case number 33 of 10, where the plaintiff is a party to the, where the plaintiff is also a party as JDR 1B. By way of this amendment, the plaintiff is seeking to declare that the order passed in OS number 33 of 2010, the execution of the sale deed is not binding on him. The execution proceedings are within the knowledge. If the petition is executed with the orders passed in execution in OS number 307 of 93 and execution number 33 of 10, he has to prefer an appeal against the order. By way of amendment, the plaintiff is trying to change the nature of the suit. Though the relief claim in the suit or partition that the execution case, that the partition, what is this? Suit for partition. The execution case pending in execution number 33 of 10 is not binding on the plaintiff's karma. The plaintiff by way of this amendment is challenging the order passed in execution, which cannot be permitted as sought for by the plaintiff. Accordingly, court had dismissed. Next, parallel counsel appearing for the petitioner submits that he has filed the application before the trial. He is seeking execution. He is seeking the declaration in respect of a property, in respect of which what is that? Before that? In respect of the scheduled properties and also a permanent injunction. Now, the suit scheduled property of this suit for declaration is this very same property in a specific performance suit. Already a decree is passed in which the plaintiff is not a party. In the execution in the year 2014, he was made a party and the land council submits that he has appeared before the court and has submitted that he is not a proper and necessary party. He submits that unless this prayer is sought, it would cause a lot of hardship to the plaintiff. The court has failed to consider all these aspects in its work. Land counsel appearing for the defendant submits that when a remedy is available to the petitioner as an objector or under section 47 of the CPC, without assailing the said reliefs, he has come before this court. He submits that a decree which was granted in the year 2006, they couldn't execute it even till today.
2007, decree was in 2007.
Could not be executed even till today. He submits that only with an intention to drag on the proceedings and to see that the defendant do not enjoy the fruits of the decree, these kind of frivolous petitions are filed. He had relied on the judgment of the apex court in case of Srimati Ved Kumari. Within brackets, dead through her legal representatives, commerce closed, Dr. Vijay Agarwal versus Municipal Corporation of Delhi through its commissioner, arising out of civil appeal
Civil appeal is not.
Number.
SLP numbers.
arising out of the SLP numbers 12601 to 12602 of 2017, dated August 24, 2023.
Neutral citations are there.
Huh?
Neutral citations
Are there? What is that?
Neutral citation.
He has relied on it so in 2023 IN SC 764. And he has relied on another judgment in case of Pradeep Mehra versus Hari Jeevan J. Jetwa and others, reported in 2023 INSC 958. Relying on these judgments, and counsel submits that the plaintiff can only file an application either under section 47 or under order 21 as an objector, order 21, rule 97. 97 as an objector, but he cannot file an independent suit. And when the amendment itself is barred by res judicata and also the law of limitation, whereas the document is of the year
1994. The agreement is of the year
1990.
93.
No. Agreement dated, the
Agreement
agreement dated 22/6/89. When the OS suit for partition was pending, that time he has done. And in this agreement, my share has also been,
What is
Yeah,
it? Original
89.
suit for specific performance.
original suit for specific performance was in 1993. 93.
The original of the year 1993, and they cannot pursue the they cannot file a suit for that. Next part. Having heard the counsels on either side, there is a material on record. Now the application is filed under order 6/17, and he wanted to seek, by way of amendment, seek a declaration that the suit, the judgment and decree in the specific performance suit, that is OS number
307.
307 of 90.
7 of 90.
307 of 93. 93 is not binding on him, and also the order that is passed by the court in execution case number
33 bar
33 bar
33 bar
2010.
2010,
10.
dated
That's
The order was passed on 30/10/2015.
30/10/2015. That came to be dismissed by the court, observing that the petitioner plaintiff was a party to the execution proceedings. And when the party was, when he was added as a party, and the court has ordered that when the court has held that, when he has filed his objections, when he was impleted, the court has given a finding that he is not a proper and necessary party to the suit. The same was not questioned by the plaintiff. The plaintiff, when an order is passed by a competent court, when he has a remedy and being a party, his remedy is to question that order passed by the court. Undoubtedly, he is not a party to the suit. He has filed the suit seeking a declaration. And while considering this application, this court has to look into the parameters where an amendment can be ordered. The amendment admittedly is much before the trial. Whatever is the case of the party, he can be permitted to, he can be allowed to raise all those grounds. It is a case of the defendant that it is barred by res judicata, it is barred by limitation, and he has taken several other grounds. All these grounds will be open to the defendant to come up before the court with an appropriate application. The court will decide the same in due course. On the face of it, the relief that is sought by the plaintiff, as far as seeking a declaration that the judgment and decree is not binding on him, is not binding on him, he can maintain such a relief. When it comes to the second relief, when he says that the order passed in the execution is not binding, to which he is a party and which he has not chosen to question, that cannot be included by way of this amendment. His remedy is to question the order by way of, by procedure known to law, provided that is within the limitation. Next part. Considering all the facts and circumstances of the case and the arguments that are raised by both the parties, this court is passing the following order. The order dated so and so.
23/11/2018.
The order dated so and so is set aside. And the application seeking amendment of the pleadings is partly allowed, whereby the prayer with regard to the declaration that the judgment and decree in OS number so and so is not binding on him is allowed. And the other prayer that is sought, as far as that is concerned, the application, the other prayer that is sought, that the order passed in the execution dated so and so is not binding on him, is dismissed. Number two, both the parties are at liberty to file appropriate applications. The defendant is at liberty to file appropriate application if the relief that is sought is barred by any law. Accordingly disposed.
Madam CM for petitioner.
For the petitioner,
Petition.
Lords, what I've been informed now is just now the respondent counsel has filed a memo in the year 2020 stating that the contesting respondents have passed away. Now they're not come on record in the trial court also, in the appellate court or in this court, so I would not be able to proceed, my lord, as that date.
It is stated that a memo is filed by the respondent stating that the appellant is no more.
Not appellant, respondents, both 1 and 2.
One is respondent 1 and 2 are no more. And counsel for the petitioner seeks time, poses matter after 3 weeks. If the steps are not taken.
My lord, I would not be able to because they're not come on record in the trial court also, my
Then
lord.
who gave you this?
The respondent himself. They filed it in the year 2020. It's on record, but it's not been put up.
He must have given the details.
Details, he just give me a memo. It's already filed in court. This is the memo. He just give me a copy of the memo.
How can the respondent file a memo?
He's filed a memo along with the death certificate. Is what he claimed outside court. So he told.
Is he here?
He was here. He gave this memo and he told it's no point me staying, and then he left.
What is this?
I don't
He
know.
has to engage the advocate and just like that giving a memo and going.
I cannot answer on his behalf.
You know that how can that memo be taken on record?
No, he told he's filed it in the year 2020 itself. That is what he claimed. And he gave me a copy and
Witnesses are served on him.
not he was a caveator.
David is filed by the advocate.
Yes, please, my lord.
Then where is this advocate?
The advocate itself gave me this memo.
Poses matter tomorrow. No representation for the respondents. When the name is reflected, it's the duty of the advocate to represent the matter. It appears that the respondents died in the year 2020 itself, without even furnishing the details to the
He claims he's
petitioner.
filed it, my lord.
Huh?
He claims he's filed it.
Details, where are the details?
He claims he's filed it. That's what.
Give it to you also.
He just gave me a memo. He told the death certificate is filed here.
That should also be given to you.
Yeah, that's not
Copy
being
and
given.
everything. Without giving proper details to the petitioner, he cannot be expected to take the steps. This is matter tomorrow. Huh? Yes, tomorrow, day after tomorrow. She says they'll get another list. Tomorrow. Yes, next.
Not top of the list, my lord.
Well, you can't expect that.
37, no, 38. Till number 38. Narendra, yes, for
No
petitioner.
representation for dismissal on 23rd.
Till number 39. Keshav Reddy, M for petitioner. Dilip.
For the respondent.
Must waste time to file LR application minutes.
When did the petitioner die? When the petitioner died or respondent died,
No, it has been abated, ma'am.
abated,
Yes, yes, it has been abated. Previously, order has been passed.
and then what remains?
27/2/20.
Despite grant of time to take steps in respect of deceased respondent number 3, no steps were taken till date. Hence, writ petition is abated. That's over. Now we have to argue on the merits of it with respect to respondent 1 and 2. If you are not interested, list this matter day after tomorrow for arguments, orals. The petition will stand dismissed against other respondents also.
Your Lordship, may I make a mention? I'm for respondent number 2, 4, 5, 6, 7, and 8, Your Lordship. Legal counsel's name has been reflected. I'll have to take and file fresh for Kala, Your Lordship.
We will see, you're a respondent.
Please.
Yes.
Number 40,
Achha.
Nanja Reddy PN for petitioner. 40,
No representation for dismissal day after.
cell number 41,
Respondent.
Vishwajit.
Suit is for a permanent injunction. The plaintiff claims to be the owner of the property. There are two
Suit is
suits.
for permanent injunction.
Yes, Your Lordship. There are two suits, 8706 and
What has happened? What is the IA?
yes, Your Lordship, the IA is under Order 14, Rule 5, seeking for framing of additional issues. The defendants filed that. Your Lordship, they filed it at a very belated stage after their evidence also.
Come to the impugned order.
Yes, Your Lordship.
The impugned order is that
order is
ink
on
page
page
number 10, annexure A, my lords.
10, it starts on 10, but the order actually starts from 11.
Yes.
Your Lordship,
Yeah, the suit is of which year?
suit is of
13.
13.
Oh, for the recasting of the issues.
Yeah, framing of additional issues, not recast.
What were the issues framed?
February 2014. 2014.
The original issue,
Original issues. In 2019, they filed this IA and it is ordered on 23/8/2019.
Yes.
My lords, the very defense, my lords, here is a case, my lords, what happens is that, my lords, the plaintiff claims to be the owner of a particular sect of land, my lords. That is land bearing survey number 13/7, 13/14 and 13/16 and other two lands, my lords. My lords, through that land, my lord, there is existing road. My lords, over there, my lord, the panchayat, my lords, what they do is that, my lords, under the scheme of Namma Grama, Namma Raste, what they do is that they want to, it's a muddy road, they want to improve the road by using the funds given by the MLA over there. My lords, by using that fund, we were trying to bring out a road over there, to improvise the road, which was already there. My lords, at that point of time, my lords, the plaintiff was also present when the Gudli Puja was happening over there. My lords, thereafter, my lords, he files the present suit. In the suit, my lords, he claims to be the owner of a particular, these sets of lands. And he claims that the road which is there, my lords, it's adjacent to my land, to his land. And for the purpose of widening, the land is being encroached. That is not the case here in my lords. Case is that my defense is that in my written statement is that, my lords, the land passes through the road, passes through the land. And the land was existent from before itself. And the villages were already using those land. To improvise that land, my lords.
That I understand. That's not the merits of the matter now.
Yes, ma'am.
2014 issues are framed.
Yes, my lord.
Why 2019 an application for recasting?
My lords,
To frame additional issues? What
lords,
are the new things that have come on record?
my lords, for that reason, my lords, the additional issues were also allowed on cost of rupees 1,500, my lords. If my lords may peruse. Nevertheless, my lords, the issue now
The
which is
issues that
being
are framed.
framed, my lords.
What are the original issues that are framed? Where is it?
Your Lordship, it is, one is whether the plaintiff.
Where is it?
My lords,
It's not,
they have mentioned it at ink page number 4 of the petition, my lords.
You that, take that.
the certified copy.
They have mentioned the original issues in the written writ petition.
The suit for bare injunction.
My lords,
Court
it's a
might
suit
go into the
for.
question of that. Why should there be a finding or a issue with regard to title?
My lords, the suit is one
because-
for bare injunction is an admitted fact.
Correct.
My lords, nevertheless, my lords, the possession which they are claiming to be is on the basis of a title.
So-
And we are disputing the title, my lords.
Lordship,
For
this
this reason, my lords, because there is a road which passes through the land. For that reason, we had sought for framing of these issues, my lords.
I am the owner of the property and by virtue of that I am in possession of the property and you are interfering. Court by deciding the issue, granting permanent injunction will instantly go into the title also. And there need not be any issue with regard to title in that. Why should, no, the court will declare his title to the property.
Indeed not, my lords. The issue is, my lords, is
No,
that,
the issues that are framed are sufficient.
my lords, we are disputing the entire absolute owner itself, my lords, because the road passes
No,
through the
then the
land.
issue is when the defendant is denying the title of the plaintiff.
Yes, my
What
lord.
is the remedy of the plaintiff? The remedy, whether he can maintain a bare suit for injunction is a different issue, which will be decided by the court. Why
Indeed,
can he maintain a suit for injunction without seeking declaration?
that is what, my
Right
lords,
of the law laid down by the.
Anatula Sudhakar.
Sudhakar's case is a
Yes,
different
ma'am.
aspect.
Yes,
So,
ma'am.
this is not necessary. Let the court proceed and whatever objections you, whatever
Lordship,
that the
just
court.
one-
will-
My lords,
One
nevertheless,
aspect, your Lordship, only one aspect is, this is a new stand that they do not admit title. This is taken up today. In fact, in their written statement, they clearly admit my title.
It is not what for him to take, it is a settled
no.
law.
Yes, your Lordship, I'm saying,
Let's-
Settled law, court will court will
Even-
decide it.
if I may, my
While
lords.
deciding it, court will decide that issue.
Yes, your
When the defendant is denying the title of the plaintiff, whether bare suits for injunction for maintainable or not will be decided.
My lords, if I may,
The question.
yes.
if I may, my lords. Now that, my lords, the impugned order says that there are 3 issues which were framed. One is on the title. Second, the other 2 issues are based on the proper court fees as well as the pecuniary jurisdiction. These are, and the court has stated that these are to be dealt as a pecuniary jurisdiction. Sorry, my lords.
What are these issues for in a suit of 2013 and 2019?
Let those 2 issues survive, my lords. Let it be heard along with the main matter at least, my lords. Because the court fees as well as the pecuniary jurisdiction.
That as far as the court fee is concerned, that has to be, that's the duty of the court to ascertain. Let the court ascertain, even the pecuniary jurisdiction also will follow that. Let those 2 issues be there. One issue will delete that issue. Agreed with the orders passed in I number 6 in OS number 719 of 2013, dated 23/8/2019. The plaintiff is before this court. Plaintiff has sought for injunction, has filed a suit for a bare injunction. In that, the court has originally framed the issues. The issues are it's with me or we have given it back?
It's with your Lordship.
My lords, the issues are also present at ink page number 4 of the writ petition. They have
Page
mentioned
number?
4 of the writ petition. the preliminary issues on the issues which are framed in the earlier stage.
Is whether the plaintiff proves that he is in possession and enjoyment of the plain scheduled property. Number two, whether the plaintiff further proves that the defendants are widening the road by encroaching the plain scheduled property. Whether the plaintiff is entitled to permanent prohibitory injunction as sought for. And the fourth is what order or decree. Now, the defendants have filed this application to frame the additional issues. It is stated that the suit is based on title, property is a vacant land, and the possession follows title in respect to the vacant land. Since the suit is based on title, the issue regarding the title requires to be framed. And the court, by order impugned, had framed three issues. One is whether the plaintiff proves that they are the absolute owners of the plain scheduled properties, whether the plaintiff have paid proper court fees, and whether the court has pecuniary jurisdiction. While framing the said issues and allowing the application that's filed by the defendant, that as per the dictum laid down by the apex court in the year 1989 SC 1809 and the year 1970 Kerala 310, the court felt that it is necessary to allow the application on a cost of rupees 1,500. Next para. Aggrieved thereby, the plaintiff is before this court. Learned counsel submits that when the petitioner is seeking, the petitioner plaintiff is seeking the relief of injunction, the court cannot decide the title of the parties, and such an issue is unwarranted. So the original issues are framed in the year 2014. And now in the year 2019, they've come up with this application, which is not permissible. The issues that are framed are basing on the issues that are already framed in the year 2014. The court can decide the issue. It is submitted that the order needs to be set aside. Next para, learned counsel for the respondent, defendant submits that court was considering the case of the plaintiff, according to whom she is the absolute owner of the property, which is denied by the defendant. As such, an issue in that regard needs to be gone into by the court. And further, with regard to the proper court fee and the pecuniary jurisdiction, the court has framed the issues which are relevant. And there is no intention on behalf of the defendant to proceed with, to drag on the matter. And the court had rightly allowed the application. Next para. Having heard the counsels on either side, there is a material on record. The suit is filed for injunction. According to the plaintiff, she is the owner of the property. According to the defendant, he has denied the title to the property. While deciding a suit for injunction based on the fact that he is the owner of the property, court can always go incidentally into the question of title, and in that regard, no issue is required. In the considered opinion of this court, issue number 1 is not relevant in the facts and circumstances of the case. Coming to issue number 2 and 3, where the plaintiffs have paid proper court fees and where the court has pecuniary jurisdiction, it is for the court to decide, even if the court has not earlier decided, and in the facts and circumstances, it is required. Court can always frame those issues. In that view of the matter, this court is passing the following order. The order of the order dated so and so is set aside as far as framing of issue number 1 is concerned. In respect to the other 2 issues and the costs that are imposed, the order of the court is kept intact. Next, the parties are at liberty to advance to take their respective arguments accordingly disposed of. What about the next matter?
Same matter, similar matter.
That is about?
Same issues.
One more my neighbor has
Another
filed the
suit.
same
Another suit.
for his property, because road runs through his property also. Same.
So same injunction, all the same. Same. order.
Lordship, there's one aspect, only one, very small, Your Lordship. Your Lordship, in the order, there's a statement which is made that the defendant denies my possession. The title, that is not true, Your Lordship. So that might run contrary to my case. He clearly admits my title in his written statement.
Is it so?
Yes, I'll read it out, Your Lordship.
Yes, Mr. Counsel.
My lords,
Only today he has raised this contention contrary to his written statement.
It's not your case.
That's why I raised an objection that only when there's a
My lords,
cloud.
if my lords may kindly peruse the written statement, my lords. In this connection, the good, I'm sorry, my lords, my apologies, my lords.
That,
Here we say that,
that one.
here
as
we
far as
say
this
that the,
contention that they deny the title that you remove.
here we say that the property runs through his land.
Yes.
That reason, my lord.
Yes.
Yes.
Next.
Sorry, ma'am.
42.
Shaker Shetty for petitioner, S.C. Shura.
For respondent, my lord.
I appear for petitioner, my lord.
File is, actually file is misplaced. Your lordship may have this matter on Monday, my lord. I will go on with you.
It is submitted with the land council respondent, the flight,
Take
the
the
file is
copy.
misplaced, this is matter on Wednesday.
Or else one copy extra is there. I can get it and I will,
Look at,
yes.
yes.
Court officer may be directed to give the copy.
Case number 43, V.B. Gunjan for petitioner. Vedamurthy.
No representation. This is matter on 4th of February.
Case number 44. K.R. Lingaraj for petitioner.
Respondents.
For petitioner, my lord. On earlier occasion, my lord, I made a submission, my lord. There is a possibility of settlement between the parties, my lord. It's a suit for specific performance, my lord.
We will vacate the stay, then you work out the possibilities of.
See, today,
Because court cannot
Ye-
keep the
yesterday-
proceedings.
yesterday,
Nobody stops you. You can tell this lower court,
yesterday,
trial court will do it.
respondent is not keeping well. He's hospitalized ಅಂತ ಹೇಳಿದ್ದಾರೆ. That's why, my lord.
At the request, finally, list this matter on 29th. No further adjournments will be granted.
2 weeks, my lord.
No, no.
Continue.
You do all your mediation, all your settlements before the trial court. Any matter be pending before this court.
Till then, interim order.
May I please, Your Honor? Lordship, the present before this honorable court, no such exercises has been conducted by the other side. And
Is
then,
there, you said respondent is unwell.
no, respondent is, because I am representing the respondent, I am the plaintiff in the original suit, Lordship, and the
Will
respondent.
list this matter on. Why is it such a submission is
Sorry,
made by your
my,
client?
my client made a such a submission.
Very wrongful, wrong.
He
submission.
talked with him, but
No, Lordship.
the
Because
mediator.
as per the
please-
instructions
please,
of my
for a
client-
moment,
When did the mediation take place? What was the,
There's
what
no
is
medi-
that, how it has happened?
there is
Tell the
no-
court.
no mediator, my lord. The person who, middleman, my lord, he said so to my,
This is
that's why, my
matter,
lord.
this is matter on 28th.
No, Lordship.
And no further adjournments will be
no-
granted.
Lordship,
We'll hear the matter.
27 it's, Lordship,
Huh?
because I supposed to.
27, it's not possible for the court.
I supposed to come from Davangere, Lordship, that's,
Huh?
I supposed to come from Davangere.
And then we will have some other day if you want.
Yes, Lordship. In the-
We'll have it on 30th.
Yes, Lordship, not before the first or second, Lordship.
And then we'll have it on 4th of February.
Much obliged, Lordship,
Yeah.
much obliged.
Till then, my lord, interim.
But tell your client not to give
Sir,
this kind of.
I will
instructions to-
seriously inform. I seriously inform.
It is very seriously, you should
Please,
inform.
ma'am, please. Also, I
Yes,
really.
what is it?
45.
Till then, interim orders.
Interim order earlier granted is extended. If it is extended on the last occasion, then extend. Yes.
Sorry, ma'am.
45. Vagishan for petitioner.
No
Dismissal.
representation. List this matter on 5th of February,
Case number 46.
same order.
Case number 47. R.B. Sadashivappa.
For petitioner.
Malappa PM for respondent.
Defendant writ petition. Suit for declaration and for injunction, my lord. Declaration regarding the easementary rights of the defendant's property and consequential relief of injunction.
Listen this matter, sir. Give a date for all the matters. 47 to 54. Give the date as 3rd February.
The next week.
3rd February.
Third.
In all the matters wherever there is interim order, please extend it. Ask him to.
25. Interim order has not been extended, my lord. Kindly extend the interim order.
What happened to 25?
My lord, order 5 to 20 application has been allowed, my lord.
No, what has happened today in 25?
My lord, I have filed an application under 5 Rule 20, my lord. The Honorable Court has directed to the council, my lord, take paper publication, my lord.
You are not there and the order is passed.
I beg your apology, my lord, some,
In that matter, no, that paper publication, interim order, look at it, if it is extended on the last occasion, in all the matters wherever interim order is there, they will be extended and they will be taken up on 3rd of February.
48 may I request me to come on Monday, my lords.
Huh?
48 matter on Monday. But some difficulty tomorrow and afternoon. 48 minutes. Otherwise, I am ready. Monday I will.
3rd February, all the matters
3rd
are added
February.
to 3rd February.
48 minutes.
It is not yet called, we'll have it on 3rd February.
Oh, much obliged.
All that, wherever interim order is there, extend.
ಅಲ್ಲಿ ಕಾಮನ್ ಆಗಿ ಅದಕ್ಕೆ ತಾನೆ ಇಲ್ಲಿ ಮಾಡ್ಬಿಡೋಣ ಕಾಮನ್ ಆಗಿ ಮಾತಾಡೋದು ಆರ್ಡರ್ ಶೀಟ್ ಕಾಮನ್ ಆಗಿ ಆಗಿದೆ ತಾನೆ ಡಿಕ್ಟೇಷನ್ ಹೌದು ಕಾಮನ್ ಕನೆಕ್ಟ್ ಮಾಡಿ
ನಮ್ಮ ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಅಲ್ಲ
Interim order election. 43 3rd February. ಎಲ್ಲ 3rd February. 43 na. 4th February.
52
43 4th February.
ಅಲ್ಲ ಇವ್ರು 48 ಅಂದ್ರು
48 ಬಂದು 3rd February.
ಇಲ್ಲಿಂದ
ಅಲ್ಲಿ
47 ಇಂದ from 47 ಇಂದ 3 to
52 ಮೇಡಮ್ 3rd February
46 5 to
52
ಎಲ್ಲ 3 to ಇದು ಲೇಟ್ ಆಗಿ ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ಸ್ ಬಂದ್ರೆ ಅದು ಇಷ್ಟು ಅಂತ ಹಾಕಿದ್ದು ಯಾಕಂದ್ರೆ ನಮ್ಮ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಂಡಿಂಗ್ ಅವರ್ ಅದನ್ನ ಡೇಟ್ ಕೊಡ್ತಾರೆ ಮೇಡಮ್ ನಿಮ್ಮವ್ರು ಏನೋ 4 ಗಂಟೆಗೆ ಪೋಸ್ಟ್ ಆಗ್ಬೇಕು ಲಿಸ್ಟ್ ಅಂತ ಹೇಳಿದ್ರು ಮಧ್ಯಾಹ್ನ ಫೋನ್ ಮಾಡಿದ್ರು ಅದು ಏನಾದ್ರು ಡೇಟ್ ಬಂತು ಅಂದ್ರೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಮಾಡ್ಬೇಕಂತ ಮಾಡಿ ಯಾವ ಮೂಡು ಬರೀ ಡೇಟ್ ಕೊಟ್ರೆ ಅಷ್ಟೇ ಮೂಡು ವೆಲ್ಲಿನ ಅಡ್ವಾನ್ಸ್ ನಾವು ಮೆಮೊ ಕೊಟ್ಟಿರಲ್ವಾ ಅವ್ರಿಗೆ ಯಾವುದೇ ನೀವು ಏನೇನೋ ಹೇಳ್ಬೇಡಿ ಹೇಳಿದಷ್ಟು ತಿಳಿಸ್ಕೊಡಿ ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ಸ್ ಇಫ್ ಇಟ್ ಈಸ್ ಕಮ್ ಅದ್ರಲ್ಲಿ ನಿಮ್ಮ ಲಿಸ್ಟ್ ಪೋಸ್ಟ್ ಆದ್ಮೇಲೆ ಬಂದ್ರೆ ಅದನ್ನ ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ಸ್ ನ ಲಿಸ್ಟ್ ಮಾಡಿ ಡೇಟ್ ಅಂತೇಳಿ ಹುಡುಗಿಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಹೇಳಕ್ಕೆ ನಮ್ಗೆ ಒಂಥರ ಅದೇ ಹುಡುಗಿ ಅದು ಶಾರದಾ ಇದು ಜೊತೆ ಇದಾರಲ್ಲ ಅವಳು ಸರಿಗೆ ಫಾಲೋ ಅಪ್ ಮಾಡ್ಕೊಳ್ಳಲ್ಲ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್